Hi, good evening. I'm also the defense's bailiff, so I asked that I would also have access to the chat to put the other times as well.
Okay, I see we got our last two judges. Miss Bias, can you tell me that you're here and that you have your ballot open?
I am here and I have my ballot open.
All right, perfect. And Mr. Garmo, do you have your ballot open?
I do.
All right, perfect. I guess that means you are all ready to begin whenever you are ready.
Sounds good. I'm just going to double check on back end. Let's see. Everybody bear with me just 1 second. I need to check on one thing related to my ballot because I have it open, but it's not showing as open on our end, and then we'll get started. All right, I think I have got it resolved on my end. We are all good to go. So my scoring judges, if you can go ahead and turn your cameras off, and we can go ahead and get going.
Your Honor, the state is ready to proceed with introductions and pretrial matters.
Sounds good. Let's start there. State, whenever you're ready, I will hear you for introductions.
Yes, Your Honor. Good afternoon. On behalf of the state, my name is Lucy Demsky, D-E-M-S-K-Y, alongside co-counsel Aiden Connors, C-O-N-N-O-R-S.
Good evening, Your Honor.
And co-counsel Maya Newman-Toker, N-E-W-M-A-N-T-O-K-E-R. Your Honor, we also have a few pretrial matters, but we'd be happy to let the defense proceed with introductions as well.
We're going to do that. So defense introductions whenever you're ready.
Thank you, Your Honor. Good evening, Your Honor. On behalf of the defense, my name is Halima Lee, and here with me today is Aditi Tata Chaudhary
Good evening, Your Honor.
and Dhritli Vadakonda.
Good evening, Your Honor.
We represent the defendant, Izzy Gardner, in the case before you today.
All right, good evening to all of you. Ms. Dembski, I'll go back to you. Do you have anything else preliminarily before we get going?
Yes, Your Honor. We'd just like to establish that this is a jury trial and all proceedings should be treated as such. In
Understood.
addition, all exhibits have been pre-marked and both parties have agreed to adhere to those pre-markings.
Sounds good.
In addition to those pre-marked exhibits, exhibits 1, 2, 3, 8, 11, and 12 have been pre-admitted into evidence.
Sounds good.
And finally, all witnesses have been constructively sequestered, except for Detective Barnes, a witness for the state, and the defendant, Izzy Gardner. And all witnesses have been constructively sworn in for the purposes of time.
So with constructive sequestration, you're requesting to invoke Rule 615, except for the 2 witnesses you mentioned?
Yes, Your Honor.
All right, so we'll consider that invoked. And aside from Detective Barnes and Defendant Gardner, everyone else has been constructively sequestered.
Yes, Your Honor.
Anything else?
Your Honor, the defense, I apologize.
That's okay. Ms. Dembski, you're all finished?
Yes, Your Honor. The state's ready to proceed with opening statements.
All right, defense?
Your Honor, the defense has no preliminary matters. We're ready to proceed with opening statements as well.
All right, sounds good. Let's go ahead and move to opening statements. To my scoring judges, I would recommend that you view opening statements in speaker view and state whenever you're ready. We'll hear from you.
Yes, Your Honor. May it please the court, counsel, and members of the jury. Desperation, deceit, and $7,800. Those are the 3 keys to understanding today's case. Now, if you happen to go into the Walters Art Museum in Chesapeake City today, you'd see a lot of beautiful art, a lot of priceless art. But what you wouldn't see is the Madonna of the Candelabra, or Springtime by Monet, or the Rubens vase. 3 pieces of culture, beauty, and history were taken by Izzy Gardner, the defendant. This is a case about desperation, deceit, and $7,800. On the night of January 4th, 2020, 2 security guards, Jamie Banerjee and Casey Hudson, were working the night shift at the Walters Art Museum. At around 1:30 in the morning, 2 individuals dressed as police officers rang the intercom at the front entrance of the museum. Acting upon first instinct, the 2 security guards let in these people they thought were police officers. But it quickly became clear that they had made a horrible mistake, because the people they let into the museum were not police officers. They were thieves. The thieves tied up Miss Banerjee and Miss Hudson. They threw them to the ground. They blindfolded them. And then one of the thieves made their first mistake of that night. They spoke. And when they spoke, Miss Banerjee was able to recognize the voice. It was the defendant. That's why we've charged Izzy Gardner with theft and assault. Now, we hold the burden of proof in today's case, and that's a burden we welcome. We need to prove beyond a reasonable doubt each element of theft and assault. We're confident that we're going to meet our burden today. To show you how, we'll call 3 witnesses to the stand. First, we'll call Jamie Banerjee, the security guard who was working there that night. Miss Banerjee will tell you that she was friends with the defendant when they worked at the Walters Art Museum together. And that's how she was able to recognize the defendant's voice when he spoke in the museum. You'll also hear Miss Banerjee testify that the defendant had a gun-like shape on his utility belt, and that he said to Miss Banerjee, "Sit quietly, don't make me use this, don't do anything dumb, and you'll both be fine." Next, we'll call Detective Barnes to the stand. Detective Barnes will tell you that she conducted this investigation and that she considered Mr. Gardner a suspect because he was identified in the museum that night. You'll also hear Detective Barnes was suspicious of the $7,800 cash deposit the defendant made the day after the art heist. Now, members of the jury, today we expect the defense is going to try and tell you that this $7,800 in cash came from some Uncle Andy as a Christmas present through the mail. So when Mr. Gardner comes to testify today, ask yourselves, was this some Christmas present, or did this money come from the art heist? Finally, we'll call Dr. Jordan Matthews, an expert in telecommunications, to the stand. Dr. Matthews will tell you that he tracked Mr. Gardner's cell phone that night, and the data he collected will show you that Mr. Gardner couldn't have been where he said he was. Members of the jury, throughout today's trial, I want you to consider three important things. Who was desperate enough to commit this crime? Did the defendant tell the truth about where he was that night? And did this $7,800 in cash come from some Uncle Andy, or did it come from the art heist? Because members of the jury, today we're going to show you that the defendant was desperate. We're going to show you that the defendant was deceitful. And we're going to prove that the defendant is guilty of theft and assault. Which is why at the end of today's trial, my co-counsel Aidan Connors is going to come before you and ask that you find the defendant guilty on all charges. Thank you.
Thank you, counsel. Defense, whenever you're ready.
Yes, Your Honor. May it please the court. 14 years old, Izzy Gardner started working at 14 years old to support himself and his mother. After graduating high school, he traded his time and youth to working jobs just to survive. To make matters worse, Mr. Gardner was arrested for robbing the Walters Art Museum and assaulting its security guards. Today, the state is charging Mr. Gardner with theft, second-degree assault, and first-degree assault. Members of the jury, the state is accusing a 19-year-old of committing a museum robbery of thousands of dollars and assaulting security guards at gunpoint. On the night of January 4th, 2020, Mr. Gardner was working late at the Engineers Club with his roommate, Armani Lee. Upon arriving home at around 1 a.m. in the morning, Mr. Gardner realized that he had forgotten his wallet back at the club and set about to retrieve it before it went missing forever. After diligently searching and searching, Mr. Gardner eventually found his wallet in the alleyway between the club and the museum, figuring it must have fallen out that evening when he was carrying heavy trash bags to the dumpster that sat there. Mr. Gardner then made it back home at around 2 a.m. in the morning and followed his normal routine until he was approached by the police on January 6th. Detective Barnes of the Chesapeake City Police Department sat Mr. Gardner down and informed him of the robbery that took place at the museum. Mr. Gardner, stunned by the news, received an even greater shock when Detective Barnes began to accuse Mr. Gardner of the crime. Detective Barnes told Mr. Gardner that she had eyewitnesses placing him at the scene. However, security guard Jamie Banerjee claims that she never saw anything to identify any of the robbers as Mr. Gardner. Moreover, Detective Barnes' search of Mr. Gardner's apartment did not turn up any of the missing artifacts. Detective Barnes then closed this case without investigating anyone else. And 2 days later, on January 8th, Mr. Gardner was arrested for simply being nearby the wrong place at the wrong time. Today, the defense will call 3 witnesses to the stand. First, the court will hear from Izzy Gardner himself. Mr. Gardner will attest to the fact that his cell phone pinged from the area where the robbery took place only because he went back to the area to retrieve his wallet. Mr. Gardner will explain how he never once stepped inside the Walters Art Museum. Given his love for art, Mr. Gardner will explain that he could never rob the Walters Art Museum. Next, we will call eyewitness Armani Lee to the stand. Ms. Lee will testify that Mr. Gardner went back to the area where the robbery took place only to retrieve his wallet. She will also attest to Mr. Gardner's completely normal behavior that night, showing no signs or hints of planning to rob the Walters Art Museum. Ms. Lee will then explain how there was nowhere in their shared apartment to hide artifacts that large or that bulky, as well as how Mr. Gardner never previously expressed any knowledge or experience of guns, being the peaceful and gentle person that he is. Based on all her knowledge, training, and experience, Dr. Kenya Ibarra, an expert in telecommunications, will attest to the fact that the account of events given by Mr. Gardner is entirely consistent with the forensic evidence in this case. She will then explain that the potentially incriminating location pings from Mr. Gardner's phone are within the likely margin of error for cellular location technology. She will then explain that it is completely possible that Mr. Gardner was in the alleyway between the club and the museum on the night of the robbery, rather than the museum itself. Today, the prosecution has the burden to prove their case beyond a reasonable doubt. I remind you that reasonable doubt is when proof is close to an absolute certainty, and that there's no reasonable situation that could have occurred other than what the prosecution presents. Ladies and gentlemen of the jury, Mr. Gardner was entangled in this case due to the loss of his wallet, a wallet that contained most of his means for survival. One may say that Mr. Gardner was at the wrong place at the wrong time, but Mr. Gardner was not even in the wrong place. He was only nearby. A nearby presence does not equate to crime. Thus, we ask you to find the defendant, Izzy Gardner, not guilty of theft, not guilty of assault in the second degree, and not guilty of assault in the first degree. Thank you.
Thank you, counsel. We're going to pause for just a moment here to allow all judges to get caught up on scores and comments, and I'll let you know when we can call our first witness. All right, state whenever you're ready. Feel free to open your case.
Thank you, Your Honor. At this time, we would call Ms. Jamie Banerjee to the stand.
All right, Ms. Banerjee, you're under oath. You can testify. Your state, you can proceed whenever you're ready.
Thank you. Good evening, Ms. Banerjee.
Good evening. Good evening, Your Honor.
Could you please state your name and occupation for the court?
Sure. My name is Jamie Banerjee, and I work as a security guard at the Walters Art Museum.
Do you like your job?
I love my job. I mean, I love the people I work with and the people who come to the museum. It's really just a great environment.
Who were your coworkers around November of 2019?
Well, the other two security guards were Sydney Ross and Casey Hudson. And then I also worked a lot with Izzy Gardner.
How did you know Mr. Gardner?
Well, Izzy and I were pretty good friends, and he was also the assistant to the museum curators, and he was super interested in the art at the Walters.
Could you tell us a bit more about what you mean by that?
Sure. Well, for example, one night I caught him hours after the museum had closed in a back room, just like intensely staring at a painting. I asked him, I was like, Izzy, what are you doing? He was like, I just got lost in thought.
How long was Mr. Gardner at the Walters?
Well, he started working there in high school, and then he actually got fired around late November, early December of 2019. So about 2 years.
Did you witness the event where Mr. Gardner was fired?
I did. So I walked into the Walters Art Museum, and Izzy and Sydney Ross, the security guard, were in this huge screaming match. It was crazy. I mean, Izzy screamed, "You're gonna regret making me your enemy. Don't make me take matters into my own hands." And then Sydney screamed something else back. It was really bad. Our boss tried to separate them, but Izzy was so upset, he just kept screaming. So our boss fired him.
Did you stay in touch with Mr. Gardner after he was fired?
No, I don't think we actually talked again until the night of the robbery, January 4th.
What were you doing that night?
Well, that night, I had the night shift at the Walters with Casey Hudson. So we got there at around 8 p.m., checked doors and locked things up. And then at 10:30, I took my break in the alleyway behind the Walters, and that's where I saw Izzy.
I want to take a step back and talk about where you were that night. Ms. Banerjee, do you recognize this document?
Yes, that's the layout of the Walters Art Museum.
At this time, we would move this exhibit into evidence and have it
Any
published
objection?
to the jury.
No objections, Your Honor.
It's admitted.
Let the record reflect that I'm going to be asking Ms. Banerjee to annotate for demonstrative purposes only where she was at certain times of night.
Sounds good. And defense, if you have any objections at any point, feel free to raise them.
Yes, Your Honor.
So, Ms. Banerjee, where did you spend most of your shift?
Well, most of all of our shifts as security guards are spent at the security desk, right around there.
Where did you see Ms. Gardner? Mr. Gardner?
Well, I went to take my break in the alleyway that's in between the Walters Museum and the Engineers Club, and that's where I saw him.
What was your interaction like?
Well, it was actually kind of weird. I mean, Izzy was walking out of the Engineers Club with a bag of trash, so I figured he must have gotten a job there. And I was excited to see him and catch up. I mean, I said, "Hey, Izzy, it's good to see you." But when he saw me, his eyes went really wide and he kind of avoided looking at me. And then he said, "Hey," pretty quietly, and then walked back inside fast.
What did you do at that point?
Well, it was freezing cold that night, so I just went back inside to where Casey was at the security desk.
When was the next eventful thing that happened that night?
Well, the next eventful thing that night was the robbery. So around 3 hours later at 1:30 a.m., Casey and I were sitting at the security desk and we heard the buzzer ring, which meant somebody was at the front door, around there.
Who was at the door?
Well, we looked through the live feed camera and it looked like 2 police officers. They had complete police uniforms on, but we couldn't tell who they were or anything because they had full face masks and gloves on. But I mean, at the time it made sense because it was really cold that night.
You mentioned a live feed camera. Does the Walters have any other security features?
Yeah, so there's the live feed camera, the buzzer, and a call box at the front door. And then we usually have a bunch of cameras, but they were actually down that night.
So did you let the 2 people at the door in?
Well, they spoke to us through the call box and then Casey let them in.
What happened when they came inside?
Well, as soon as they came inside, I could tell something wasn't right. I mean, they closed the door and they told us to kneel with our heads facing the desk, and then they took our hands behind our backs and put us in zip ties.
What happened next?
Well, I was so confused. I mean, I still thought these people were cops. So I asked, what's going on? Am I being arrested? And the person who seemed to be in charge came up to me and he said, "Sit quietly. Don't make me use this. Don't do anything dumb, and you'll both be fine." And when he said, "Don't make me use this," he gestured to this area on his belt, and I realized the other robber had it too. It was a gun-shaped bulge.
What happened next?
Well, after that, they blindfolded us, and I'm pretty sure they took Casey into another room. And then I got a second to think. And I realized I knew who was robbing us. I recognized his voice. It was Izzy Gardner.
What were you thinking in that moment?
I mean, I was just surprised and upset. I mean, Izzy and I were great friends for a long time, and I couldn't believe that he could do something like robbing the Walters. So I started to second guess myself and try to convince myself maybe it wasn't him. I mean, I knew I had seen him earlier, and I thought maybe I was just making a connection to him that wasn't there. But then I heard his voice a second time.
What did the thieves say this time?
Well, he came into the room and he said, "We've got what I wanted, let's go." And that time, almost all my doubt had gone away. I mean, it was Izzy's voice.
How did you know it was him?
Well, Izzy and I were good friends for like 2 years. We even spent Thanksgiving together one time. I mean, I can recognize his voice pretty easily.
So, what happened after that?
Well, I'm pretty sure the robbers left out the back door, like in the staff area. And then I was just sitting in the dark for, I think, hours until Sydney Ross came for her shift. And she found me and Casey and called the police and untied us.
Did you speak with the police when they arrived?
I did. I spoke with Detective Barnes and I told her everything that happened that night and that I heard Izzy Gardner's voice twice.
Thank you. No further questions at this time, Your Honor.
All right, cross-examination.
Yes, Your Honor. May I proceed?
Whenever you're ready.
Good evening, Ms. Banerjee.
Good evening.
I want to first talk about your relationship with Mr. Gardner. You said that it was out of character for Mr. Gardner to rob the museum, correct?
Objection, improper character testimony.
Do you want to explain?
Your Honor, if I may.
Let me have State explain
go
the
ahead.
objection, and then I will get to you, I promise.
Certainly. A witness's credibility can only be bolstered after it's
Yes,
first
Your Honor.
been attacked. And in this case, it hasn't yet been attacked. This character's reputation for truthfulness.
All right, defense, your response.
Yes, Your Honor. I'm simply attempting to establish that Ms. Banerjee on direct said that she recognized Mr. Gardner's voice on the morning of the robbery and that she believed the robber was Mr. Gardner himself. But I'm simply establishing the fact that Ms. Banerjee believes that Mr. Gardner that conviction or that activity couldn't have been performed by Mr. Gardner himself.
May I respond, Your Honor?
Sure.
The testimony that the defense counsel is trying to elicit is actually propensity evidence, that because Mr. Gardner had a character trait in the past that he would act in accordance with that character trait, that because Ms. Banerjee didn't think he had the character of the person to rob a museum, he wouldn't rob a museum, and that's not permissible under Rule 401A1, which you can find on page 24 of the casebook.
All right, defense, do you have a response specifically to the notion that this is impermissible character evidence?
Your Honor, I'm not asking Ms. Banerjee to testify to Mr. Gardner's character, but rather to her understanding of Mr. Banerjee, Mr. Gardner.
All right, the objection is overruled. You can continue, counsel.
Thank you.
Ms. Banerjee, I'll repeat the question. You think that it's out of character for Mr. Gardner to rob the Walters Art Museum, correct?
I mean, when I realized that it was Izzy's voice, I was just so surprised that it was him. Like that I had been friends with somebody for like 2 years who could do something like that. So I was really coming up with any reason that it couldn't have been him. I mean, yeah, it didn't seem like something he would do.
So you're coming up with reasons to believe that I wasn't Izzy Gardner, isn't that right?
Exactly. I mean, after I heard the voice the first time, I couldn't believe that it was him. I didn't want to believe it was him. And I still don't. But after I heard the voice the second time, I couldn't deny it.
Right. And Ms. Banerjee, you even said that you're not really sure whether the voice belonged to Izzy Gardner. Isn't that right?
Well, after I heard the voice the first time, I wasn't sure. I mean, I had only heard it once and I really didn't know. But once I heard it the second time, I mean, almost all of my doubt was gone.
And you even believe that the voice didn't belong to Izzy Gardner. Isn't that right?
No, I don't think that's true.
Ms. Banerjee, is your testimony here in court today that you believe that it was Izzy Gardner on the morning of the robbery?
After I heard the voice the second time, I was positive.
But you did believe that the voice didn't belong to Izzy Gardner, correct?
At first, I thought there may be a possibility that it wasn't him, but I couldn't shake the feeling that it was.
Now, Ms. Banerjee, you keep mentioning how hearing the robber's voice for the second time confirmed that it was Izzy Gardner, but isn't it true that the robber actually spoke much quieter the second time?
Yeah, well, Izzy came back into the room, I think. I heard footsteps. And yeah, it sounded like he was trying not to be identified. He spoke a little bit more quietly to the other robber.
Right. And the 2 times that you heard the robber speak, it actually sounded like, in your own words, a robber attempting to disguise his voice to make it sound like Izzy Gardner. Isn't that right?
Exactly. I mean, Izzy probably could recognize me and Casey and knew that we'd be able to recognize his voice.
Now, Ms. Banerjee, this is only your opinion, correct?
I mean, I'm pretty sure that I heard Izzy Gardner's voice.
But it is your opinion, correct?
Yeah, that I heard Izzy Gardner's, sorry.
Asked and answered.
Your Honor, if I may.
That's all right. Overruled. I think she's clarifying. You can continue.
Ms. Banerjee, would you like me to repeat the question?
No, I've got it. Yeah, it's my opinion that I heard Miss Gardner's voice twice.
Right. And why don't we talk about what happened after the robbery occurred? Didn't your colleague Sydney Ross untie you?
Yeah, she did. She was coming for her shift in the morning and she found me, and then we found Casey. Thank God she was fine, and called the police.
And after that, you found Casey, right?
Yeah.
And weren't you asked if you could identify any of the robbers?
Oh yeah, Casey asked me if I recognized anybody. I'm not really sure why, but I said I couldn't. I mean, I think I was just shaken up. Honestly, I didn't really feel safe until the police got there, and I could tell Detective Barnes everything.
So just to be clear, Ms. Banerjee, you never told your coworkers that you thought one of the robbers sounded like a previous coworker, Izzy Gardner, attempting to disguise his voice, correct?
No, I didn't say that to Casey.
Right. And on the morning of the robbery, you also never saw the robber's face. Isn't that right?
No, I mean, even before they blindfolded us, both robbers had full masks on, so it would have been impossible to see.
Thank you. No further questions.
No redirect, Your Honor.
All right, fantastic. Ms. Banerjee, you're excused. Thank you for your testimony.
Thank you.
State, give us just a few moments. I'll let you know when you can call your next witness. All right, state whenever you're ready. Call your next witness.
Yes, Your Honor. At this time, the state calls Detective Barnes to the stand. May I proceed?
Whenever you're ready.
Good afternoon.
Good afternoon. And good afternoon, Your Honor.
Can you please state your name and occupation for the court?
I'm Detective Murphy Barnes, and I'm the Chief of Criminal Investigation at the CCPD.
How did you become the Chief of Criminal Investigation?
Well, I joined the police department right out of college and I just worked my way up. I joined the Department of Criminal Investigation in 2009 and I worked my way up through that to my current role as head of that department.
What do you do in your day-to-day work?
Well, fundamentally, I'm a detective. I take on cases, I collect evidence, I speak to witnesses, I speak to suspects, and ultimately try and solve those cases.
Have you ever been the lead detective on any case before?
I have. I've been the lead detective on over 500 cases.
Now, detective, I want to move on and I want to talk about today's case. What were you doing on the night of January 4th and the early morning of January 5th?
Well, that was the night of the art heist at the Walters. So I was contacted around 5 a.m. I went right there and I arrived with a couple of dispatch officers.
What happened when you arrived at the scene?
Well, the first thing we did was secure that scene. And after that, I focused my attention on the 3 people who were there when I arrived.
Who were those 3 people?
All 3 were security guards, Jamie Banerjee and Casey Hudson, who had been there throughout the night, throughout the robbery, and Sydney Ross, who had arrived that morning. So I separated all 3 of them and I spoke to all 3 of them.
What did you learn when you spoke to all 3 of them?
Well, after that, I found that I really had a person of interest, a suspect in this case, and that was Izzy Gardner. Mr. Gardner was identified as one of the thieves. Jamie Banerjee heard his voice and—
Objection, Your Honor, hearsay.
May I respond?
Yes.
Your Honor, this testimony, we're not offering it for the truth of the matter asserted. This testimony is going to go towards Detective Barnes's investigation and why she took the next step in her investigation. We're not offering those identifications as the truth. That's what Ms. Banerjee just did on her direct examination.
Response?
Yes, Your Honor. The fact that Detective Barnes is asserting that Jamie Banerjee said that she identified one of the guards, identified Mr. Gardner as one of the robbers on the morning of January 5th does go to the truth of the matter, and it is hearsay because it is not something that Detective Barnes knows. Rather, it is something that only Jamie Banerjee can attest to.
May I respond?
Sure.
Your Honor, I'd like to clarify that we're not using this evidence for the truth of the matter asserted. In fact, we'd be happy to offer this testimony with a limiting instruction to the jury, which tells them to take this testimony not for the truth of the matter, but for why Detective Barnes took the next step in her investigation.
All right. As to the statements, because I think the only statement on the record right now is one of Jamie Banerjee. So as to the statement of Jamie Banerjee specifically, I will overrule the objection. And you can continue, counsel.
Thank you, Your Honor. Detective, would you like to continue your answer?
Thank you. And I also concluded that none of those security guards were suspects at that time.
So you just told us that Mr. Gardner was a person of interest. Did you talk to him?
I did. I went to his house that Monday, the 6th, and we had a conversation. And during that conversation, something just seemed to be off about Mr. Gardner.
What do you mean by that?
Well, at this point, it had been over 24 hours since the robbery at the Walters. The Walters is a well-known museum. Mr. Gardner lives about 3 blocks from it. Mr. Gardner used to work there. I believe Mr. Gardner now works right next to it. So I assumed he would have heard something. But when I got there, he seemed surprised. He acted like he had no idea this had happened. So I found that quite strange.
So what did you do next?
The pieces of art that were stolen from the Walters, these were valuable artifacts, you know? There was a big monetary factor in this case. And so I pulled my suspect's bank records.
Your Honor, at this time, let the record reflect I'm displaying a copy of Exhibit 7, which can be found on page 108 of your casebook, constructively outside the presence of the jury. Detective, do you recognize this document?
Yes, those are Mr. Gardner's bank statements.
Is it a fair and accurate representation of those bank statements?
It is, yes.
Your Honor, at this time, we'd like to have Exhibit 7 entered into evidence and published to the jury.
Any objections?
No objections, Your Honor.
It's admitted.
Thank you. So, Detective, what did you notice about these bank statements?
When I looked at this, there was really just one thing that stood out to me, and that's that on January 6th, Mr. Gardner made a remarkably large cash deposit, $7,800.
So, did you ask Mr. Gardner about this cash deposit he made?
I did. I called him that same day, the 7th, and I just wanted to see if there was a reasonable explanation for where this money had come from.
And was there?
Well, actually, at first, I didn't get any explanation at all.
What do you mean by that?
Well, I called Mr. Gardner, and the first time I mentioned the money, he says, "You know about that?" And after I said, "Yes, I do," and I asked again where it came from, he paused for a really long time.
How long did Mr. Gardner pause for?
About that long.
Let the record reflect the witness just paused for approximately 10 seconds. So, Detective, did Mr. Gardner say anything after he paused?
Yeah, eventually I got some vague story about an uncle without an address, without a phone number, who sent this cash through the mail weeks ago, but I personally didn't think it was a reasonable explanation.
Why not?
Well, based on my knowledge, my training, my expertise, often young or inexperienced thieves have to offload what they've stolen really quickly and for much less than its market value. So I think that that could have happened here.
So what did you do next after talking to Mr. Gardner?
Well, at that point, I thought that there was probable cause to arrest Mr. Gardner, so I applied for a warrant and I did.
After you arrested Mr. Gardner, did you close your investigation?
I didn't. I wasn't 100% certain that I had the right person in custody, and I wanted to get just a little bit more information.
What information, if any, did you gather?
Well, I called the FBI, I told them that, and I asked them for their art crime team report. And I also asked Dr. Matthews for his cell tracking report.
And did you receive those two reports?
I did. I received Dr. Matthews' report first, about a week later. And once I read that, all of my suspicions were pretty much confirmed. So at that point, I closed my investigation and the FBI is still handling the rest.
Thank you, Detective. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
Whenever you're ready.
Good evening, Detective Barnes.
Good evening.
Now, you investigated Jamie Banerjee, Casey Hudson, and Izzy Gardner, correct?
They were all a part of my investigation.
And isn't it true that Miss Hudson actually contradicted Mr. Banerjee's account of the robbery on January 5th?
Objection. Hearsay.
If I may respond, Your Honor.
Sure, and you're objecting, what are you objecting specifically to?
Yes, Your Honor. We're objecting to any statement made by Miss Hudson. She's not in court today, and therefore anything she wrote or said to Detective Barnes outside of court is being taken for the truth of the matter.
All right, response?
Yes, Your Honor. It is actually clearly stated that Detective Barnes followed up with Miss Hudson once, and I was simply just eliciting what knowledge she learned from that conversation, and whether or not it did contradict Miss Banerjee's statements.
So are you going to be trying to point out to the witness specifically what the contradictions were?
No, I'm simply asking if there is a contradiction at all, Your Honor.
All right, state any response to that?
As long as Miss Hudson's testimony or what she wrote in her statement or affidavit is not brought into court today, then we have no objection.
If I may respond.
Oh, sure, go ahead.
Oh, sorry. I just wanted to clear for the state that it's nothing in Miss Hudson's affidavit or in her statement. It's simply just the conversation that detective had with Casey Hudson.
So here's the ruling I'm going to make. If you want to ask this witness about contradictions, that's fine. If you go into specific statements, I'm not ruling on that at this point. I'm not letting either of you know how I would rule. But if you do go into that and state you want to re-raise your objection at that time, you can. Based on the testimony on the record right now, I'm going to overrule the objection.
Yes, Your Honor.
Thank you. Detective Barnes, would you like me to repeat that question?
No, that's okay. There were a few minor discrepancies between the two security guards, so I called Casey Hudson to clarify.
And Detective, you even stated that it would be difficult to focus your investigation on Izzy Gardner without Casey Hudson's eyewitness account, correct?
That's right. One, identification is, pretty strong in an investigation. Two is even stronger.
But you even learned through your investigation that Casey Hudson was actually blindfolded during most of the robbery, correct?
Objection. Yes. I'd like to renew my hearsay objection.
As to what specifically?
As to any testimony from Miss Hudson. I believe, if I may proffer, that opposing counsel is referring to what Miss Hudson wrote in her statement, and that's how Detective Barnes knows about this. But, Your Honor, I believe that's hearsay.
Response?
Yes, Your Honor. I'm simply asking through her investigation what she's learned about Casey Hudson in general.
And why is that not hearsay under these circumstances?
This isn't hearsay because this is part of her investigation, and she has firsthand knowledge as to what happened that night, as she was the detective on this case.
Okay, so those specific statements, the specific statements of Casey Hudson, the objection is sustained.
Thank you. Move to strike those statements.
I don't really think anything came in, but such that it did come in, it will be stricken.
Thank you, Your Honor.
I'd be happy to move on, Your Honor. Now, Detective, there were 3 pieces stolen on the morning of January 5th, correct?
Yes, that's right.
That's the Madonna of the Candelabra, Rubens vase in Springtime, correct?
Yes.
Let the record reflect that the defense is presenting exhibit number 1, which has already been pre-admitted. Detective, are you able to see exhibit number 1?
Yes, I am.
And do you see this as the report that you made on this robbery?
The forensic report, yes.
Yes. Now, directing your attention to the DNA analysis section that you conducted, you didn't find any DNA of Mr. Gardner on the morning of January 5th, 2020, correct?
No, we didn't. We found some DNA from the security guards and from some unidentified individuals.
Right. You found in your report that Miss Ross's fingerprints, one of the security guards, was on the lower left exterior of one of the stolen paintings, Springtime, correct?
That's correct. But, she worked there. She was a security guard. I wasn't surprised that her DNA was found there, and it was found in a lot of other places too.
Right, but you still found it suspicious, so you decided to follow up, correct?
I didn't find it suspicious that we found her DNA, no.
But you did decide to follow up with Miss Ross as to why her fingerprints were there, correct?
No, I called Miss Ross after I found out she quit her job.
Right, now you called Miss Ross, but you didn't get anyone on the line, correct?
That's right.
Her phone was out of service, yes?
Yes, that's right.
In fact, you even went out of your way to go to her home, right? And no one was there, right?
Right. I mean, when I heard that she'd quit, I thought maybe she knew something she hadn't told me. Maybe I could get a little bit more information, but I thought that was unlikely. And so I stopped pursuing her at that point.
And Detective, you also learned that Miss Ross quit her job just 2 days after the heist, correct?
That's correct. I was told that by the other security guards.
Right. So after you learned her phone was out of service, no one was home, and that she quit her job, you still didn't use department resources to try and locate Miss Ross, correct?
No, Miss Ross was never a suspect. Miss Ross was never identified by people who knew her, who were there that night. And so I didn't want to waste resources pursuing something that was unlikely to give me any more information.
So, Detective, you failed to follow up with Miss Ross as to why her fingerprints were present on the frame of a stolen piece of art, correct?
No, I never needed or wanted to ask Miss Ross about that. I didn't think it was unusual.
All right, now let's talk about your investigation of Izzy Gardner. Now, Mr. Gardner even let you search his apartment when asked, correct?
Part of it, yes, that's right.
Right, and in the parts that you did search, you didn't find any physical evidence related to a robbery, right?
No, I didn't. It appeared normal.
In fact, the 3 pieces of stolen art still haven't been recovered today, correct?
I believe that's correct, but the FBI is still trying their best.
Right, the FBI is involved in this case, right, Detective?
Yes.
Right. At this time, let the record reflect that the defense is presenting exhibit number 8, which has already been pre-admitted. Detective, can you see exhibit number 8 on your screen?
I can. Thank you.
All right. Now, on this report, you even admitted to FBI agent Jack Kelly that you, quote, weren't sure that you had the right person, correct?
Right. That was just after I'd arrested Mr. Gardner, and I wasn't 100% sure, but I actually was 100% sure after I read Dr. Matthews' cell tracking report.
Now, Detective, let's scale back a little bit and talk about your investigation of Mr. Gardner. You never asked Mr. Gardner where he was on January 5th, correct?
Well, I told Mr. Gardner that the Walters had been robbed and that he was identified. And, you know, I expected he would say, no, I wasn't there, I was doing this, but he didn't really say anything.
But you never explicitly asked Mr. Gardner for his story on the morning of January 5th, correct?
No, I assumed he would give it to me, but I didn't explicitly ask.
Thank you, Detective. No further questions.
Any redirect?
No redirect, Your Honor.
All right, the witness is excused. Thank you, Detective.
Thank
And
you.
State, give us just a moment and I'll let you know when you can call your next witness. All right, State, whenever you're ready, call your next witness.
Yes, Your Honor. At this time, the state calls Dr. Jordan Matthews to the stand. May I proceed?
Whenever you're ready.
Thank you, Your Honor. Good evening.
Good evening. Good evening, Your Honor.
Could you please state your name and occupation for the court?
My name is Dr. Jordan Matthews, and I run a telecommunications firm called Matthews Consulting, which I started, that specializes in cellular tracking analyses.
Did you need any sort of special education to run that firm?
Well, I earned my bachelor's in telecommunications in 2006, and in 2010, I completed my PhD in applied engineering and mathematics.
Have you ever testified before as an expert in the field of telecommunications?
I've testified more than 25 times at both the state and federal levels, although to be fair, I've never testified on Zoom before.
Thank you. Your Honor, at this time, the state offers Dr. Jordan Matthews as an expert in telecommunications, specifically as it relates to the analysis of cellular data.
Defense, any objection?
Defense has no objections to admitting Dr. Matthews as an expert in telecommunications.
All right, the witness will be tendered as such, and State, you can continue.
Thank you. Dr. Matthews, how did you prepare for court today?
My consulting firm has an ongoing contract with the Chesapeake City Police Department, so at their request, I prepared an investigation into one of their cases, and I also provided a supplemental report after reviewing the defense expert's opinion.
I want to talk about both of those things, but before we get into them, I want to make sure we all understand the basics of cellular tracking. Let the record reflect I'm displaying a copy of what's been pre-admitted as Exhibit 12B. Do you recognize this document?
Yes, I do. That's a pictorial diagram of a cell tower and a cell phone.
Could you explain for us how cellular tracking really works?
I'll try and keep it brief and not bore you to sleep. But essentially the way it works is that each cell tower will provide cell service to a given area. And we can break that area into thirds because each cell tower comes equipped with 3 antennas. In this diagram, they're labeled X, Y, and Z. So we can look over the cell phone records of a suspect, identify which antenna and which tower they're connected to, and therefore learn what area that suspect must be located in. In this image, you can see that the cell phone would connect to antenna X tower 1, and therefore is in an area much smaller than, say, the rest of the page.
So when you do this kind of work, this kind of tracking, do you only need to look at what tower and what antenna someone's connected to?
No, of course not. There are a few pieces of contextual information that we need to use to corroborate our initial findings, and signal strength is a perfect example of that.
What do you mean by signal strength?
Your phone will connect to whatever tower has the strongest signal in your location. That makes sense. The piece that is somewhat unintuitive is that the tower that is providing the strongest signal might not always be the cell tower that's closest to where you are. That unintuitive piece is why we have to study signal strength.
Now I want to move on, and I want to talk about your investigation in this case. Were there any cell towers that were particularly important?
Cell towers 16 and 109 were of note.
Let the record reflect I'm displaying a copy of what's been pre-admitted as Exhibit 12C. Do you recognize this document?
Yes, I do. It's a map of Chesapeake City with cell phone tower 16 overlaid.
You just said that this tower was important. Why is that?
From 1:38 to 1:50 a.m. on the early morning of January 5th, Mr. Gardner connected to cell phone tower 16 antenna X. You can quite clearly see that antenna and tower provide cell coverage to the Walters Art Museum, which was being robbed at the time that Mr. Gardner connected to it.
Now I want to move on, and I want to talk about your supplemental report of the expert witness for the defense, Dr. Kenya Ibarra's work. Was there anything you and Dr. Ibarra particularly disagreed on?
Yes. We most disagreed on the role that margin of error played in today's case.
What's margin of error?
Well, in order to combat dead zones and make sure that everyone gets the best cell signal possible, 2 antennas of the same tower will overlap at their boundary. Now, this overlap naturally causes a bit of imprecision, or what we could call a margin of error.
Well, why wasn't this imprecision important in this case in your mind?
Well, margin of error certainly exists. The issue is in this case, we're not concerned with the boundary between 2 antennas of the same tower. Rather, we're interested in the boundary between 2 different towers. Therefore, signal strength is a much more relevant piece of evidence.
Where did signal strength show up in this case?
It showed up at the boundary between cell phone towers 109 and 16. And geographically speaking, that would be the alleyway and the engineers club.
Let the record reflect I'm displaying a copy of what's been pre-admitted as Exhibit 11E. Do you recognize this document?
Indeed, I do. This is the map of Chesapeake City with most of its cell towers.
So you just said that these 2 towers were where signal strength showed up in this case.
Objection, Your Honor. If I may, this exhibit, as it's shown right now with the overlay towers, has not been approved by the defense counsel. Thus, I ask that the opposing counsel show each exhibit individually.
May I respond?
Hold on. So you're saying, so are you objecting to, I'm a little confused what you're objecting to. Are you objecting to the fact that there's 2 exhibits being shown at the same time?
Yes, Your Honor. I believe that it,
Go ahead.
it poses a risk of misleading the jury, which is why I ask that they be presented as they have been agreed during pre-admitting evidence, which is one at a time.
Brief response, Your Honor.
Sure.
We've showed Dr. Matthews both of these exhibits earlier in this direct examination. They've not been altered in any way. They've just been overlaid for clarity. We're not trying to mislead the jury at all, just make this somewhat confusing science easier for all of us to understand.
If I may respond, Your Honor.
Sure.
The fact that it is overlaid is the issue here. This does pose a risk of misleading the jury. And as we said before, this is not what the defense counsel approved to being pre-admitted into evidence. Thus, I ask that if opposing counsel wants to show 11E and 12C, that she do so individually to prevent that risk.
Just to be clear, we won't be entering this into evidence. We're just overlaying the two pre-admitted documents for demonstrative purposes.
If I may, Your Honor.
So, all right. So no one disputes, my understanding is defense counsel, no one disputes that these two, that 11E and 12C are admitted into evidence, and the towers that are being shown on the screen are accurate depictions of 11E and 12C. So your primary objection is just that they're being put on the screen at the same time, correct?
Yes. This is not what we agreed to pre-admitting. And according to Rule 403, this is needlessly presenting cumulative evidence and does pose the risk of misleading the jury, which is why I asked that the opposing counsel present what we have approved during pre-admitting evidence, if that's all right.
May I clarify briefly, Your Honor?
No, I'm going to overrule the objection. I understand counsel's point, but I think if counsel believes, defense, if you believe at any point that anything that's put up on the screen is inaccurate, is not correct, is not an accurate representation of the exhibit, you should absolutely feel free to raise an objection. And of course, because this is being used for demonstrative purposes, if at any point you'd like to use it, you should feel free to do so and simply to ask. And I will certainly require opposing counsel to display it for you. But I don't believe this violates Rule 403. So I'm going to overrule the objection.
Yes, Your Honor.
Thank you, Your Honor. Dr. Matthews, you just said that these two towers and signal strength were important in your supplemental report. How so?
Well, cell phone towers 16 and 109 are equidistant from the alleyway and the engineers club approximately. So in order to determine which tower Mr. Gardner would have connected to if they were in the alleyway.
I'll raise my objection again. This exhibit is incorrect. As we can see, tower 16X, the upper limit of the antenna doesn't cover the range that it shows in the actual exhibit itself. It's incorrect. Thus, I ask that opposing counsel present exhibit 12C as it is, as this antenna is incorrect.
Counsel for the state, do you have a response to that?
Your Honor, I don't believe that specifically is something that is affecting the use of this demonstrative. We're all limited by the technological issues that we have. It's an overlaid version of these two demonstratives. Nothing has been materially altered. All that you're seeing here is this overlay here covers up a very small portion of the other one. If you'd like us to crop the exhibit of 109 and redisplay it, we'd be happy to do that. But again, nothing at all has been altered. We're just trying to be clear for the jury.
Your Honor, if I may respond.
Hold on just 1 second. Counsel, can for the state, can you have your tech chair go back a slide and show just the exhibit?
This is the overlaid exhibit, Your Honor.
Yes, I've got that.
I'd be happy to display the original 12C once again. Your Honor, have it back just a few slides.
Yeah, if we could go back to that just briefly.
I believe the issue we have is you see here, this document extends this way, and with the overlay, you see this had to be cropped to include all of 109. If you'd like me to go back and crop it so we don't include all of 109 and we include all of 16Y and X, I'd be happy to briefly make that change.
Your Honor, if I may respond, if that's all right.
So hold on just 1 second. So I am not going to tell state counsel whether you need to crop or what you need to do, but I'm going to sustain the objection. I think that while it is small, there is a material difference between what has been pre-admitted and the overlay. And so I think at this point, defense counsel raises a correct point. So as to how you choose to cure that, I'm not going to, say one way or the other, but I am going to sustain the objection of defense counsel.
Thank you, Your Honor.
Dr. Matthews, you just said that towers 109 and 16 were very important when it came to signal strength in this case. What did you mean by that?
Cell phone towers 16 and 109 are equidistant from the alleyway and the engineers club. That is, they both provide service to that area. So when I was trying to determine whether or not Mr. Gardner could have connected to cell phone tower 16 from the alleyway or the engineers club, I needed to examine the signal strength of both towers.
Let the record reflect, I'm now displaying what I believe is corrected overlay. May I proceed with this version?
Defense, based on your earlier objection, do you have any objection to what we're looking at now?
I have no objections at this moment.
All right, that's all we can ever say. So that's fine, counsel, you can continue.
Dr. Matthews, how would you determine the signal strength of a given tower?
We look at patterns. We see which cell phone tower someone tends to connect to at a given time in a given location.
Let the record reflect I'm displaying constructively outside the presence of the jury what's been pre-marked as Exhibit 9. Do you recognize this document?
Yes, I do. These are the cell phone records I pulled from Mr. Gardner's provider.
Your Honor, at this time, we'd like to move Exhibit 9 into evidence and display it to the jury.
Any objections?
No, Your Honor.
All right, it's admitted.
Thank you, Your Honor. Dr. Matthews, you just said you look at patterns. Did you see any patterns in this data?
I found a very strong pattern. From about 4:30 to 12:30 the following day, Mr. Gardner was working a shift at the Engineers Club, and for that entire time, he connected exclusively to cell phone tower 109.
What does that tell us about the signal strength of towers 109 and 16?
It tells us that, at least in that area, a cell phone would tend to connect to cell phone tower 109. The Engineers Club is quite clearly within range of cell phone tower 16, and yet, for the entire 8 hours that Mr. Gardner was there, he connected exclusively to cell phone tower 109.
Did Mr. Gardner ever connect to any tower that wasn't 109 while he was in the general area of the Engineers Club in the alleyway?
No.
Were there any factors present on the night in question that could have changed either of these towers' signal strength?
There were not.
To a reasonable degree of scientific certainty, did you reach an expert opinion in this case?
Yes, I did.
What is that opinion based on?
It's based off of my education and experience in the field of cellular tracking, as well as my investigation in today's case.
What is that opinion?
My opinion is that because of Mr. Gardner's cell phone connection to cell phone tower 16X at the time of the robbery, as well as the signal strength of cell phone tower 109 in the alleyway in the Engineers Club, Mr. Gardner's cell phone was most likely within range of the Walters Art Museum at the time of the theft, but more importantly means that Mr. Gardner's cell phone could not have been located in the alleyway or the Engineers Club while the robbery was happening.
I'll be honest, Dr. Matthews, that was a lot of information and you had a little bit of technical language in there. And I want to make sure I understand exactly what you just told me. Do you think you could give me your opinion in layman's terms?
Absolutely. The cell phone records indicate that Mr. Gardner was not in the alleyway or in the Engineers Club at the time of the robbery.
Thank you. No further questions at this time, Your Honor.
Defense, give me just one moment, and then we'll start with cross. All right, whenever you're ready, defense.
Yes, Your Honor. Good evening, Dr. Matthews.
Good evening.
Let's talk about your analysis for this case. Didn't you say that the data that you collect and cellular tracking technology in general are very precise?
Yes, it's remarkably accurate and sophisticated.
Right, but you said in your supplemental report that you deal with imperfect technology. Isn't that correct?
Absolutely. Nothing's 100% one way or another. Suffice it to say, I've always been fascinated by the remarkable accuracy of these technologies despite the challenges that it faces.
Redirecting you back to my question, Doctor, you did say in your supplemental report that you deal with imperfect technology. Is that correct?
Yes, that's right.
Now, Doctor, your cell tower measurements, they only provide ranges of the target phone's location, correct?
That's exactly right.
So your measurements, they can't pinpoint exact individual buildings. Is that correct?
Yes, that is right. What the cell phone data can tell us is the area that a cell phone must be located within, but not the precise location of that cell phone.
Let the record reflect that I'm now presenting Exhibit 11, which has been pre-admitted into evidence. Doctor, are you able to see this exhibit?
Not yet. It's still gray for me.
Okay, let me try again. Is it visible now?
Yes, it is.
Doctor, let's talk about your analysis of Mr. Gardner's cellular data on the night of the robbery. Which tower did Mr. Gardner connect to from 1:13 a.m. to 1:37 a.m.?
I'm not completely certain.
Okay, I'll refresh your memory if that's okay with you.
Absolutely.
Right, so this is Exhibit 9. So if you look at the timestamps 1:13 to 1:37 a.m., which tower did Mr. Gardner connect to?
Cell phone tower 109.
Right. And if we look at the range 109X right here, this range includes the Engineers Club and the alleyway. Isn't that correct?
That's right.
So it's possible that Miss Gardner was in the Engineers Club and or in the alleyway when she connected at this time, 1:13 to 1:37 a.m. Isn't that correct?
Yes, that's right. That's a possibility for that 20-minute period.
Right. Now, Doctor, now I would like to direct your attention to the range 16X, which is right here. You claim that from 1:38 to 1:50 a.m., Mr. Gardner's phone connected to this range that includes the Walters Art Museum. Is that correct?
Yes, it includes the Walters Art Museum and a few blocks to the south.
Doctor, your analysis only determined that Mr. Gardner was in range of the museum, correct?
Yes, that's exactly right. This technology cannot define the pinpoint or precise location of a target cell phone.
Right, and to clarify, your data does not and cannot conclude that the target phone pinged inside the Walters Art Museum. Isn't that correct?
No. As far as the data goes, is to say that the cell phone must have been within range of the Walters Art Museum, but it can't say for certain whether or not it was there. That's right.
Now, Doctor, you said in your affidavit that the alleyway is not part of range 16X. Is that correct?
That's right.
Now, if we take a closer look at this exhibit that you yourself created, isn't a part of the alleyway, in fact, in range 16X?
That's a 1 or 2 pixels on the top right. 16X in reality doesn't provide coverage to the alleyway.
Doctor, you created this diagram, isn't that correct?
That's right.
And before you, you see that a portion of the alleyway is in fact in range 16X. Don't you agree?
Objection. I don't believe this is an exactly probative line of testimony. Both experts have agreed. I have a good faith belief both experts have agreed the alleyway is not included in the programmed range of Tower 16 Antenna X.
If I may respond, Your Honor.
Sure.
I am simply assessing the witness's credibility in making the diagrams and what he has in his written statement. As we can see here, there is clearly a portion of the alleyway in this range. I'm simply assessing the witness's credibility in the diagram that he made compared to what he has in his sworn affidavit.
May I respond?
Sure.
Your Honor, to assert that this diagram with a few pixels of overlap means Tower 16 Antenna X actually includes the alleyway is incredibly misleading to the jury, as both experts we have today in court agree that the range of this tower does not include that location. To microanalyze this one portion of a document when both experts agree that it's not a material issue will only confuse issues for the jury.
If I may respond, Your Honor.
Briefly, and then I'm going to rule.
Yes, the expert witness, Dr. Barr from the defense, has not testified yet. So the prosecution attorney is speculating as to what Dr. Barr will testify to. And regardless, this has been pre-admitted into evidence, and I'm just bringing it up before the witness. He did create this document, so I'm just clarifying a few things, if that's all right.
Yeah, so I'm going to overrule the objection. I understand counsel's point, but nothing about asking him about the diagram prevents him from testifying to what's in his report or what's not in his report. I think the witness has proven himself capable to answer the questions. And if you believe that counsel is misstating the record or anything like that, you can re-raise your objection. But at this point, I'm going to overrule. You can continue, counsel.
I'll ask you the question again. Dr. Matthews. According to what you see before you, a portion of the alleyway is in fact in range 16X. Wouldn't you agree?
I'm an expert in cellular tracking, and unfortunately, I'm not an expert in Photoshop. So yes, a portion of the alleyway is covered in this demonstrative, but I can assure you that the geographical range of 16X does not cover the alleyway as per Xfinity.
To clarify before the court, this has been pre-admitted into evidence, and Dr. Matthews just testified that he had created this exhibit. This is not a Photoshopped exhibit. Let's move on, Doctor, to margin of error. You reviewed Dr. Kenya Barr's report, correct?
Yes, I did.
And in this report, Dr. Barr talks about margin of error of cellular location technology, correct?
That was one piece of evidence that we disagreed on quite strongly, yes.
Redirecting you back to my question, Dr. Ibarra does talk about margin of error in her report, correct?
That's right.
All right. Let the record reflect that I'm now presenting Joint Exhibit 12C. Give me one moment. Is this visible to you, Doctor?
Yes, it is. Thank you.
No problem. Dr. Barr says that the antennas X and Y in the range 16 for the tower 16, they overlap due to margin of error, correct?
Yes, that's exactly how margin of error functions.
Right. And Dr. Barr says that if someone were to be standing in this alleyway, that he or she could have connected to range 16X. Isn't that correct?
Well, it would depend on the day. Signal strength is changing all the time. So if the circumstances were right, then yes. But if they weren't, then no.
Redirecting you back to my question, Doctor. You read Dr. Barr's report as you claimed, correct?
Yes, I did.
And in her report, she says that if someone were to be standing in this alleyway, he or she could have connected to tower 16X. Isn't that correct? That's what you read?
Yes, that is what Dr. Ibarra claims.
And you agree that there is a possibility that Dr. Ibarra's conclusions are correct, don't you?
There's a very slim possibility. I found her conclusions to be unlikely enough as to not influence mine in the slightest. But to your point, I'm not willing to say anything's certainly impossible.
Right. So there is a scientific possibility that Mr. Gardner is telling the truth tonight, correct?
No. To a reasonable degree of scientific certainty, that is not the conclusion I reached. But again, I'm a man of science. I'm not willing to say anything is impossible, and so I'll grant Dr. Ibarra that much. Yes.
Doctor, that was not the question I asked. The question that I asked is, there is a scientific possibility that Mr. Gardner connected from the alleyway, correct?
Objection. Asked and answered.
If I may, Your Honor.
Overruled. You can continue, counsel.
I'll ask you the question again. Doctor, there's a scientific possibility that Mr. Gardner connected from the alleyway when he was in range 16X. Wouldn't you agree?
Very unlikely, but yes.
All right. Now, Doctor, you yourself said that margin of error there's always room for margin of error, correct?
Yes.
Now let's talk a bit more about your measurements. So you said that due to margin of error, you can't, for example, determine whether a person is seated on the left or the right side of a room, correct?
Yes, that's right. Another reason we can say that is that suspect's cell phone, we can't pinpoint their exact location. We can only give an area.
Right. And you also said that due to margin of error, you can't pinpoint the target phone's location to within a few feet, correct?
That's right.
And you also said that your ranges should not be used without additional contextual information to pinpoint the location of Mr. Gardner on that night. Isn't that correct?
Signal strength is a piece of contextual information that I used. And yes, I absolutely agree. Signal strength was a piece of contextual evidence that I found very important in determining Mr. Gardner's location that night.
Redirecting you back to my question, you did say that your ranges should not be used to pinpoint the location of Mr. Gardner's phone without additional contextual information. You did say this, correct?
Yes, contextual information is very important.
Were you with Mr. Gardner that night, Doctor?
I was not.
Thank you. No further questions.
Any redirect?
No redirect, Your Honor.
All right, the witness is excused. Thank you, doctor.
Thank you.
Anything further from the state?
No, Your Honor. At this time, the state rests our case in chief.
All right, I've got 6:10 on my clock. Let's resume trial at 6:15 with the defense's case.
Yes, Your Honor.
All right. I see defense on screen and I see state on screen as well. State, we ready to proceed?
Yes, Your Honor.
And defense, we ready to proceed?
Yes, Your Honor.
All right, it's your case. Call your first witness.
Thank you, Your Honor. The defense calls Izzy Gardner. May I proceed?
Whenever you're ready.
Good evening. Please introduce yourself to the court.
My name is Izzy Gardner, and I'm 19 years old.
Mr. Gardner, what's your current occupation?
I work at the Engineers Club in Chesapeake City.
Now, let's talk about the night of January 4th, 2020. What were you doing that night?
I was working a shift at the Engineers Club with my friend Armani. I remember it was just super busy that night because there was some event for a local politician.
What time did your shift end?
Around 12:30 a.m. I remember that the event ended at around 11, so after we finished cleaning up, it was around 12:30-ish.
Let the record reflect that I will now be presenting Exhibit 3, which has been pre-admitted. Mr. Gardner, can you see the exhibit?
Yes.
Mr. Gardner, after cleaning up, where did you go?
I was walking home to my apartment with my friend Armani. I remember we were just talking all the way, so I didn't realize until we were close to home that I forgot my wallet somewhere. So I went back to the Engineers Club to go look for it.
What time did you arrive back at the Engineers Club?
Around 1:10 a.m.
And after arriving at the Engineers Club, when did you find your wallet?
It was around 1:46 a.m. I remember finding my wallet on the ground next to one of the dumpsters in the back alleyway.
Once you found your wallet, where did you go?
I just went straight home. I was tired and it was just a long day.
Now, Mr. Gardner, why did it take so long for you to find your wallet?
I was just looking everywhere. I started in the Engineers Club, but I couldn't find it inside, so I checked outside in the alleyway to see if it was there, and thankfully I found it on the ground, where I guess I must have been just throwing out some trash earlier that day. I'm just so glad that I found it. It just means a lot to me. It was my dad's old wallet, and I started using it when I was 14 years old, when I picked up my
Objection.
first job to support me and my mom.
Objection.
Stacey?
Relevance.
Response, counsel?
Yes, Your Honor. My witness is finished with his response. He's simply relaying how long it took him to find his wallet, and he also included information about why it was important to him.
What relevance does, I understand he was trying to find his wallet, that part is fine, but how he feels about the wallet, what relevance does that have to this case?
That simply takes to the case as to why he took so long to find his wallet and why he was determined to find his wallet that morning.
May I respond?
Sure.
Your Honor, how the witness felt about his wallet or who the wallet previously belonged to has no bearing on this case.
I'll let the jury decide if they want to take it for anything, but I'll overrule the objection. And I think if you said the witness was finished, counsel, then you can continue.
Yes, Your Honor.
Yes, Your Honor. I'm sorry to hear that, Mr. Gardner. Now let's fast forward to the following day. Was there anything unusual that happened on January 6th, 2020?
Yeah, Detective Barnes came into my apartment and started asking me all these questions about the Walters Art Museum. And then, out of nowhere, she started accusing me of robbing the museum on the morning of January 5th, which it didn't make any sense. I hadn't even been to the museum since the day I got fired.
Were you able to inform Detective Barnes about where you were on the morning of January 5th?
No, I wasn't given the chance to.
And what happened after that conversation?
She asked if she could check my apartment, and I had nothing to hide, so I let her.
Did the detective find anything?
No, I had nothing to hide, so there was nothing to find.
Now, Mr. Gardner, what else did you learn from the detective?
I learned that the robbers used guns when robbing the Walters Art Museum, and that obviously couldn't have been me. Guns just go against everything I believe in.
So just to be clear, Mr. Gardner, have you ever owned a gun?
No,
Have you ever even used a gun?
absolutely not.
And after that, was Detective Barnes in contact with you?
Yes, she contacted me on January 7th, the day after, to talk about the $7,800 deposit I made on January 6th.
Let the record reflect that I will now be presenting Exhibit 7, which has been admitted. Mr. Gardner, can you see the exhibit?
Yes.
If I could direct your attention to the cash deposit made on January 6th, 2020, where did this come from?
This came from my Uncle Andy. He gave me $8,000 as a Christmas gift, and I deposited most of it into the bank.
Were you able to inform Detective Barnes about where this money came from?
Yeah, I told her multiple times that this money came from my Uncle Andy as a Christmas gift, not from the robbery.
Now, Mr. Gardner, were you involved in the robbery?
No, I couldn't even imagine it.
And were you even at the museum on the morning of January 5th, 2020?
No, after grabbing my wallet from the alleyway, I just went straight home.
Thank you. No further questions.
Cross.
Whenever you're ready.
Good evening, Mr. Gardner.
Good evening.
Now, I want to start by talking about your past history at the Walters Art Museum. Is that okay?
Yes.
You worked there for a little over 2 years, right?
Yes.
You were fired from the Walters Art Museum in late November of 2019. Isn't that right?
Yes, it was just a difficult time for me. It was a job that I really loved, but I understood where my boss was coming from, and I didn't hold it against him.
Right. When you were fired from the Walters Art Museum, you got in a fight with one of your coworkers, didn't you?
I mean, it was definitely heated, but I wouldn't call it a full-out fight.
You threatened Miss Ross, the person.
Objection relevance?
May I respond?
Sure, but first, defense. So what's your issue with this?
Your Honor, opposing counsel is talking about Mr. Gardner's, the day that Mr. Gardner got fired from the Walters Art Museum, and I believe that that does not bring any relevant facts to this case.
All right, state your response.
Yes, Your Honor. I believe that the day Mr. Gardner was fired from the Walters Art Museum is relevant. And if I may proffer, Mr. Gardner got in a fight with his coworker because his coworker found out that he had a prior theft conviction, and that theft conviction is relevant to today's case as well.
Okay, defense, your response to that.
Yes, Your Honor. I will, as opposing counsel does phrase that, I will object to more prejudicial than probative.
So, okay, so if the theft conviction comes out, we can deal with that then. But specifically right now, we're just dealing with the fact that he got into a fight with one of his coworkers on the day that he was fired. And are you objecting at this point, saying that's irrelevant, or are you amending to 403?
Your Honor, I'm simply objecting that this is irrelevant, as opposing counsel has already established that there was a fight that day.
May I respond briefly?
No, I think I'm going to overrule the objection. It is part of it too, as counsel just references, that this is already on the record at this point. And I think, as to wherever it goes from here, if you want to re-raise, you can. But at this point, I think it meets the bar for relevance. So the objection's overruled.
Yes, Your Honor. Now, Mr. Gardner, you said to Miss Ross, you don't want to make me your enemy. Isn't that right?
Yeah, in the heat of the moment, I said some things that I know isn't what I should have said and isn't who I am.
But you did say that. That's a yes.
Yes, it's just not who I am.
Now, you got into this fight with your coworker because Ms. Ross found out that you had stolen from a Target, isn't that right?
Objection, more prejudicial than probative.
As to what specifically?
The theft conviction, Your Honor.
All right, so you're objecting as more prejudicial than probative to the theft conviction. State your response.
Yes, Your Honor. I do believe the theft conviction is extraordinarily probative because it happened just a few weeks before the robbery or the theft at the Walters Art Museum. If I may proffer, Mr. Gardner had to pay a $500 fine right after this conviction, and we believe that this $500 fine goes directly towards the defendant's motive for the theft.
All right, defense, your response to that.
Yes, Your Honor. In this case, I believe that the probative value is little to none and that it is outweighed by its substantial effect.
May I respond briefly?
No, I think under 403 it passes. I'm going to overrule the objection. You can continue, counsel.
Thank you, Your Honor. Would you like me to repeat the question, Mr. Gardner?
Yes, please.
You got in a fight with your coworker, Miss Ross, because she found out that you had stolen from a Target, right?
Yes, I was really having a rough time, and I didn't feel like it was her place to tell other people something that I hadn't even come to terms with myself.
Right, Mr. Gardner, I know this is difficult, but I just have a couple more questions on this line. You stole because you didn't feel like you had enough money to get by, isn't that right?
It was just a very difficult time for me.
Right after you stole, you had to pay a $500 fine, didn't you?
Yes, I had to take money out of my food money for that month and the month afterwards, and it just wasn't the best decision to steal. It put me at a worse place than I was before.
So, Mr. Gardner, you stole because you didn't feel like you had enough money, and then you were—
Objection has answered.
I don't think counsel was completely, I think she was building off of a previous question.
Yes, Your Honor.
So let me let her finish the question, and if you have an objection, you can raise it.
Thank you, Your Honor. So you stole because you didn't feel like you had enough money to get by, but then right after you were able to pay that $500.
Yes, I had to cut fees for that month and the next month, and honestly, if it wasn't for Armani, I probably would have had to leave Chesapeake City in total.
So, Mr. Gardner, I want to move on and I want to talk about the night in question. I actually want to talk about early January. You couldn't pay rent on time, could you?
Well, I did receive the money that I received from my uncle as a Christmas gift, and I was planning to pay Armani with that money, but she said she'd only take the payment in Venmo, so as a result, I first deposited it into the bank, and afterwards I gave her the rent money.
Right, so to answer my question, you paid that rent late, didn't you?
Yes.
And now you claim that you paid that rent with the money that you got from the supposed Uncle Andy, right?
Yes, it was a Christmas gift from Uncle Andy.
Without this money that you claim came from Uncle Andy, you actually wouldn't have been able to pay rent in the month of January.
Well, I was pretty close to making the money. I was almost at $600, and I was probably going to take up a few extra shifts at the Engineers Club so that I could pay my rent, even if it was a little late.
Right, so without that money that you claim came from Uncle Andy, you would have been even later on your rent.
It would have been just a little bit later, maybe a day or two, but it wasn't anything serious, I'd say.
Sure. Now, this money that you claim came in the mail, you don't actually have the envelope, do you?
No.
You don't have the note that you claim Uncle Andy supposedly wrote you, do you?
No, I don't.
You actually don't have a phone number for Uncle Andy.
I don't have his contact information.
Right, you don't have an address for this supposed Uncle Andy either, do you?
No, he just moves around a lot, so I don't know where he is at the moment.
Right, so you have no way of contacting this person you claim sent you $8,000 in cash through the mail?
Well, as of the present, no, but yes.
And you never told your roommate, Armani Lee, about this money, did you?
Objection, relevance?
All right, a response?
Yes, Your Honor. I believe that, if I may proffer, this line of questioning is going to go to the fact that this money didn't actually come from some Uncle Andy. We're claiming today that this money came from the art heist. And for Mr. Gardner to not have told his roommate, who he claims to be really close with, about this money is relevant.
Your Honor, if I may.
Sure.
What Mr. Gardner chooses or not chooses to tell his roommate does not bring any relevant facts to this case and does not disprove or prove any of the facts at hand today.
May I respond briefly?
No, the objection's overruled. You can continue.
Thank you, Your Honor. Would you like me to repeat the question again, Mr. Gardner?
Yes, please.
You never told your roommate about this money you claim came from Uncle Andy, did you?
No, I don't really talk about my family much, and I kind of wanted to surprise Armani that I had enough money to pay rent for a while.
So that's a yes, you never told her about it.
No, I'm very uncomfortable talking about my family.
All right, now, Mr. Gardner, you deposited this money on the day of January 6th, right?
Yes.
You're aware that Detective Barnes searched your apartment the morning of January 6th, didn't she?
Yes.
Detective Barnes didn't find this $7,800 in cash that you claim was there, did she?
No.
All right, Mr. Gardner. Now I want to move on and I want to talk about the night in question. You claim that around 1:30 in the morning, you had to go back to look for your wallet, right?
Yes.
Now, it just so happens that you were right next to the Walters Art Museum that night, or so you claim. Isn't that right?
Yes, I was searching for my wallet in the alleyway.
Right, it just so happens that that place you claim to be doesn't have any security cameras, does it?
No, the Engineers Club is a pretty old building.
So you spent, or you claim you spent, approximately 30 to 45 minutes outside in the January cold, right?
Yes.
Right next to the Walters Art Museum, right?
Yes, in the alleyway.
At the exact same time a theft occurred, isn't that right?
Yes, I was just searching for my wallet. It just means so much to me.
So that's a yes to my question. That happened at the exact same time a theft occurred.
Well, yes.
Thank you, Mr. Gardner. No further questions at this time, Your Honor.
A brief redirect, Your Honor.
Whenever you're ready.
Mr. Gardner, why don't you have your Uncle Andy's contact information?
Well, he just moves around so much, and I'm just unable to get in contact with him at the current moment.
And why did Uncle Andy give you that $8,000?
After my dad left, he felt terrible that I didn't have a father figure in my life, so...
Objection. Speculation.
As to what specifically?
Speculation as to why this money was sent in the mail and as to Uncle Andy's beliefs about Mr. Gardner and his dad.
All right, response, counsel?
Yes, Your Honor. Mr. Gardner, Uncle Andy is Mr. Gardner's uncle. They have their family and they do know each other. While Uncle Andy is not often in the picture, I believe that Mr. Gardner is familiar with his uncle and the place that he holds in his family.
May I respond?
Yes.
Your Honor, we've heard no foundation laid that Mr. Gardner would know why his uncle sent him that money. And Mr. Gardner can't make opinions about what his uncle is thinking or why his uncle sent him that money because we don't have the supposed Uncle Andy here in court today.
Your Honor, if I may.
Sure.
I believe the foundation has been established, as we've previously established, that this was a Christmas gift from the defendant's Uncle Andy.
Right, and I don't think there's any objection to that. I think, if I understand it correctly, the objection is to the witness going on and saying, or at least beginning to explain why Uncle Andy would have sent money to the witness Is there any, do you believe you've laid the foundation for him to be able to say that information?
Your Honor, as opposing counsel already mentioned on her cross, she asked Mr. Gardner whether she could provide the court the note that her Uncle Andy provided to her and to him and the envelope. And Mr. Gardner has already stated no as he threw that note away, but I believe that that note is sufficient to establish that this was a Christmas gift from the defendant's uncle and the purpose of why he sent that gift to the defendant.
May I respond?
Yes.
Your Honor, today we're contesting the existence of Uncle Andy. We're contesting that that note and that envelope actually existed. And so for Mr. Gardner to claim that he knows why this uncle sent him this money is speculation.
All right. I think based on the foundation we have on the record right now, as specifically only as to the motivation behind such a gift, I'm going to sustain the objection.
Thank you, Your Honor.
Yes, Your Honor. One final question, Mr. Gardner. On the morning of January 5th, 2020, when the robbery occurred and you were looking for your wallet, did you know what was going on at the Walters Art Museum?
No, I had no idea that there was a robbery going on.
Thank you. No further questions.
No recross.
All right.
Your Honor, may my witness be excused?
Yes, he's excused.
Yeah.
And defense, wait just one moment. I'll let you know when you can call your next witness. All right, defense, whenever you're ready.
Thank you. The defense calls Armani Lee to the stand. May I proceed, Your Honor?
Whenever you're ready.
Good evening. Could you please introduce yourself to the court?
Good evening. My name is Armani Lee. I'm 23 years old, and I currently am a law student at the University of Chesapeake, Francis Scott Key.
What is your relationship to the defendant, Mr. Gardner?
Izzy is my friend and roommate, and we also work together at the Engineers Club.
Where were you on the night of January 4th, 2020?
I was working my usual shift at the club. There was a local event for politicians that night, so my shift ran pretty late.
Who were you working with that night?
I was working with Izzy. We actually had the same shift that night, which was nice because I do really enjoy working with Izzy. He's a very kind and considerate person to be around, and when we have breaks, we like to talk about the customers and what's been going on those days.
And Ms. Lee, did anything happen while you were working together?
No, it was just your usual political event, and Izzy and I were working the whole night.
Did you notice anything strange about Mr. Gardner?
No, again, it was just a very busy night and everything was fine.
What time did you and Mr. Gardner finally get off that night?
We got off at around 12:30 in the morning. We had stayed back to clean up and close the club, and after we had done that, we had walked home together.
What happened on your walk home?
When we were almost home, Izzy said that he couldn't find his wallet, so he was going to go back to the club to look for it. I did offer to go back with him, but he said he'd be fine, so I let him go and I headed home.
Do you remember what time Mr. Gardner got back home?
At around 2 to 3 a.m., but closer to 2.
Let's fast forward a few days. What happened on January 8th, 2020?
I learned that the police had searched our flat. and also that Izzy had been arrested for robbing the Walters Art Museum.
Miss Lee, what was your reaction when you found out that Mr. Gardner had been arrested for robbing the Walters Art Museum?
Objection, relevance. Ms. Lee's reaction to Mr. Gardner's arrest is not relevant to today's case.
Response?
Yes, Your Honor. We're simply just asking what Miss Lee was thinking after her friend, Mr. Gardner, had just been arrested. And this is relevant to today's case because Miss Lee was with Mr. Gardner the night before, and we're simply just wondering, and we're simply just asking the witness as to whether or not she saw anything or might have, understood if there was anything happening with Mr. Gardner. So her reaction is crucial to understand as to what Mr. Gardner might have been doing the night before and that day.
May I respond?
Sure.
Testimony has already been elicited as to whether Ms. Lee thought Mr. Gardner was acting normal or anything she might have seen. The testimony about the reaction actually has no bearing on what happened the night of the robbery, and so has no bearing on today's case.
All right, the objection's overruled. You can continue, counsel.
Thank you. Now, what was your reaction when you found out that Mr. Gardner had been arrested for robbing the Walters Art Museum?
I was shocked. I just didn't understand why the police would have suspected Izzy, out of all people, to be one of the robbers of the museum. And I mean, I was working with him the whole night, and I would have noticed if there was anything off about him.
Now, prior to Mr. Gardner's arrest, did you see anything new in your shared apartment?
No, our flat is pretty small, so I would have noticed if there was anything out of place.
Finally, let's talk about the robbery. What did you learn about it?
I learned that the robbers had used guns while robbing the museum.
And in your experience, has Mr. Gardner ever talked about using a gun?
No, he has not.
And to your knowledge, as his roommate, does Mr. Gardner own a gun?
No.
At this time, no further questions, Your Honor.
All right, cross-examination?
Yes, may I proceed?
Whenever you're ready.
Ms. Lee, good afternoon.
Good afternoon.
You know Mr. Gardner pretty well, don't you?
Yes, we are close friends.
You'd say you know when he's acting normal, right?
Right, we have been living together for quite a long time.
So on the night of January 4th, when Mr. Gardner told you he forgot his wallet, he wasn't acting normal, was he?
He did sound a bit rehearsed in my mind, but it was after a long shift and it was late at night, so I just brushed it off as something that I misinterpreted.
It sounded to you like Mr. Gardner had practiced saying that line before, right?
Again, yes, it did sound a bit rehearsed, but I might have just misinterpreted it given the time and that we had worked a long shift.
Now, Ms. Lee, I want to talk about some things you might not know about Mr. Gardner. You don't know where your January rent money came from, do you?
No, it's none of my business where he really gets the money. As long as he pays the rent, that's all that concerns me.
On January 3rd, when your rent was already late, you asked Mr. Gardner where the rent money was, and he said he had a plan to get it to you, right?
Right, and I had just assumed that he was going to pick up more shifts at the Engineers Club.
2 days later, the Walters Museum was robbed, right?
That would be correct.
Now, you got the money 4 days later, and Mr. Gardner never told you where that money had come from, right?
No, again, it's none of my business where he gets the money from, just as long as he gets it to me during that month.
You never heard about a Christmas present, had you?
No, but I do remember seeing a pretty thick envelope in his post pile during that time.
He never said to you, "Oh, I got a present from my Uncle Andy," did he?
No, Izzy doesn't really talk about his family that much, and I had sensed it wasn't something he really wanted to talk about, so I didn't really pry into the situation.
So you've never heard of an Uncle Andy, to be clear?
No, I have not.
And you never saw any cash in your small apartment as you described it?
No, the envelope was pretty thick though, so I did assume it was cash, but I didn't see what was in it.
Well, you say explicitly in your affidavit you never saw any cash, and you didn't know whether there was cash in that envelope, right?
Right, I never saw it, but I just did assume it was cash given its size.
Ms. Lee, when Mr. Gardner moved in with you, he didn't tell you he had a theft conviction from just a month prior, did he?
No, he didn't.
And Mr. Gardner didn't tell you that your apartment had been searched on January 6th, did he?
No, I had been out for the day and I didn't have much contact with Izzy, so I didn't learn about it until after he had been arrested.
Right, on January 6th and January 7th, Izzy Gardner told you nothing about the fact that the detectives had come to his apartment, right?
Our flat, yes, I didn't hear much about it during that time.
Right. Now there's one more thing you don't know, Ms. Lee, and that's where Mr. Gardner was between the hours of 1 and 2 in the morning on January 5th. You don't know where he was then, do you?
No, but he said he was going back to the club to look for his wallet, and I have no reason to believe why he would do anything otherwise.
You weren't with him at that time?
No, I had gone back to my flat.
Thank you. No further questions at this time, Your Honor.
Any redirect?
No, Your Honor, no redirect. May my witness be excused?
Yes, your witness is excused. Thank you for your testimony. Defense, I will let you know in just a moment when you can call your next witness. All right, defense, whenever you're ready.
Yes, Your Honor. At this time, the defense calls our third witness, Dr. Kenya Ibarra, to the stand. Permission to direct exam this witness, Your Honor.
Whenever you're ready.
Good evening. Could you please introduce yourself to the court?
Good evening. My name is Kenya Ibarra, and I'm a telecommunications analyst.
Could you please describe your background in telecommunications, doctor?
Of course. I attended Taos University, where I graduated with a Bachelor of Science in Telecommunications in 2008. Then following graduation, I then continued my studies and I ended up founding my consulting business, Forensic Engineering Associates, in 2014. And I've been the senior partner there ever since.
And what are your current responsibilities as a telecommunications analyst, doctor?
Currently, I work with other engineers to provide consulting services to clients. I specialize in performing comparative analyses of reports. Additionally, I analyze forensic data, including cellular data, internet service data, and other location-based services.
Your Honor, at this time, the defense would request that the court accept Dr. Kenya Ibarra as an expert in telecommunications.
State, any objections?
No objection at this time. Any issues we have, we'll bring up on cross.
Sounds good. All right, the expert will be accepted in the way they were tendered, and you can continue.
Yes, Your Honor. Dr. Ibarra, as an expert, can you testify that all of your opinions will be to a reasonable degree of certainty?
Yes.
Doctor, what were you asked to do for this case today?
I was asked to evaluate the report of Dr. Jordan Matthews by performing a comparative analysis.
Now let's get into your analysis of this case. Let the record reflect that I'm now presenting Exhibit 9. Dr. Ibarra, is this visible to you?
Yes.
What methods did you use to conduct your analysis of the forensic evidence, doctor?
For this case today, I reviewed the affidavit of Izzy Gardner and analyzed each step of his alleged whereabouts that evening.
And according to your analysis of this evidence, what did you find?
I found that each instance was entirely consistent with what Gardner claims he was doing that evening.
And how did you conclude this, doctor?
After reviewing the forensic evidence, I found that Gardner first reported leaving his home at around 4:20 p.m., which is corroborated by the final connection at 4:16 encompassing his apartment. And for the next several hours, his location is static, which again is consistent with his account that he was working a shift at the Engineers Club. Furthermore, data also shows that his cellular phone connected to a tower that encompassed Gardner's apartment complex at around 12:50 a.m., which yet again is consistent with his alleged whereabouts. Lastly, Gardner's phone connected to Tower 109X, which covers the area of the Engineers Club, which again is consistent with his report that he had returned there to find his wallet.
Now let's talk about margin of error. Doctor, can you please explain for the court what margin of error of cellular location technology is?
Of course. Due to the way cell phone towers are designed, the ranges are imprecise, especially at the boundaries, and these are designed overlaps at the margins, and they are completely necessary because without these certain overlaps, there would be dead zones at the edges.
And how would the margin of error at the edges affect the findings in this case, Doctor?
Specifically in this case, at 1:38 to 1:50 a.m., Dr. Matthews' diagram makes it appear as if Gardner is in an area that does encompass where he had stated he was. But even with the slightest overlap adjustment, that could have resulted in margin of error at the edges of antenna 16X and 16Y. I found that Dr. Matthews' report had multiple flaws because he's attempting to use this imprecise data at a level of specificity that it can't provide. So I can say with reasonable degree of scientific certainty that there is a huge possibility of his phone connecting to Tower 16X from the alleyway.
Now, Doctor, let's move on to the drive test analysis that you conducted. Let the record reflect that I am now presenting Exhibit 12D. Is this visible to you, Doctor?
Yes.
Objection. Lacks foundation. May I be heard?
Sure.
Your Honor, pursuant to Rule 702C, which you can find on page 27 of your casebook, a witness who is qualified as an expert may testify in the form of an opinion or otherwise, only if that testimony is the product of reliable principles and methods. We haven't had the foundation laid that this is a reliable principle and method, and to go directly to the findings from this test, which I believe is what is being displayed right now, is not something which Dr. Ibarra can yet assert.
Your Honor, if I may respond.
Sure.
This piece of evidence has been pre-admitted, which means that the prosecution counsel has approved this document, and I believe that it doesn't make entire sense for it to be pre-admitted and not to be testified upon. Thus, I request that my witness be allowed to testify upon this document and her findings. As it has been pre-admitted and that's stipulated, I can direct you to the stipulation if necessary.
No, that's, and State, I'll go back to you in just one second, but I mean, I agree that this document is pre-admitted. The witness can testify to what is listed on this document. So I certainly wouldn't entertain any objection to that. But State, what's your response to defense counsel's response?
Just that, Your Honor, if the testimony will go beyond just reading what is on this document, presenting these findings, if it will go to analysis or basis of further testimony or opinion, that be kept out unless there is proper foundation laid that this is a method that is used in the field, that this is a method that has been entered into a court of law, as we have a good faith basis that it is a controversial method in the field.
If I may respond, Your Honor.
Sure.
Again, like I've said, opposing counsel has approved this exhibit and has been pre-admitted, and thus I ask that it be acceptable for the witness to respond her conclusions or her analysis based on what has been pre-admitted into evidence. Again, I am happy to lay any foundation if necessary, but regardless, I would ask that my witness be able to testify to her conclusions on the drive test, which has been, again, pre-admitted into evidence.
May I briefly respond, Your Honor?
Well, so here's what I'm going to do. So we're kind of talking past each other here. This document has been pre-admitted. No dispute there. I don't think the witness had started to go into conclusions yet, but what I'm going to do is I'm going to overrule the objection, but state if you believe that the witness testifies to conclusions that you have an issue with, you should feel free to re-raise your objection at that time. At this point, though, given where we are, I don't think we've heard anything that's that's in violation of the rules. So I'm going to overrule the objection for now.
Yes, Your Honor.
I'll ask you the question again, Doctor. Can you please explain for the court what a drive test analysis is?
Sure. Drive tests provide very crucial information which can help determine what is possible at the moment in question. And for this case today, I conducted a drive test analysis with Gardner's cellular phone, which was an attempt to recreate the conditions of the original connections in order to determine what was possible under similar conditions.
Can you please explain what the data on this pre-admitted exhibit means to the case today?
I found from reviewing my drive tests that the drive test just proves the basic science behind cellular tracking technology, which is that the margin of error that comes with the boundaries makes it impossible to know exactly where Gardner's cellular phone was at the crucial moments.
Renewed objection of 702C to extend the drive test to assertions about Mr. Gardner's location and Mr. Gardner's cellular records.
If I may respond, Your Honor.
Sure.
I would ask that if the prosecution attorney has any issues with the methods used, that she address that in cross-examination. Like I've said before, opposing counsel has approved this document to be entered into evidence. Thus, I believe it wouldn't be fair for my witness not to be able to testify to the data that this document includes. So I ask that, again, if the prosecution attorney has any opposition or issue with the methods specifically, that she address that in cross-examination.
May I respond?
Sure.
I'd just like to clarify, there was testimony that came out just as to what is on this document. It's in evidence, the jury can review it. But what we are specifically objecting to is the assertions and the opinions that Dr. Ibarra has further offered about what this document tells us about Mr. Gardner's phone on the night in question. And pursuant to Rule 702C, an expert may only testify in the form of an opinion or otherwise if that testimony is the product of reliable principles and methods. I have a good faith belief that this is neither a reliable principle or method.
Your Honor, if I may.
Sure.
Dr. Ibarra has been entered as an expert, and she has conducted drive test analysis today. So I ask that as an expert witness, she be able to testify upon her analysis. The prosecution attorney had no problem admitting our witness as an expert. So I believe it's only fair that she testify to her expert conclusions in this case today.
May I briefly clarify, Your Honor?
No, I understand I understand the points that both of you are making. I mean, state counsel, I'll ask you this before I rule. I mean, so you're objecting to a lack of foundation as to the 702C. Am I correct about that?
Lacks foundation, that there hasn't been foundation laid about whether this is a reliable principle or method. If there is more foundation laid, we may raise the objection again. But just that we don't know whether this is a reliable principle or method yet. And I have a good faith belief that it is controversial.
If I may respond, Your Honor.
I'm going to give you one more response and then I'm going to rule because we got to keep this moving.
Yes, of course. I'll be happy to lay the foundation. I'll be happy to. But as far as I know, this witness has been admitted as an expert witness. This document has been pre-admitted into evidence. Thus, I believe it's only fair that the witness testify to her expert conclusions based on this pre-admitted stipulated document.
Right. So here's the ruling I'm going to make. So my understanding of the objection, no one's objecting to this document. This document is in, there's no doubt about that.
Yes.
I am going to sustain the objection only as it pertains to foundation and ask defense counsel to just lay foundation as to the nature of this test. I'm not ruling on the test itself, just on the nature of the foundation that we have on the record right now. And so on that regard, in terms of the test itself, I'm going to sustain the objection, and defense counsel, you can continue.
Yes.
Right. I'll lay some foundation. Dr. Barra, are drive tests what is the status of drive tests in your field?
Drive tests are heavily supported by other experts of telecommunications like myself, as I do utilize them very regularly while conducting comparative analyses and reviewing of reports. Additionally, they have been admitted in criminal investigations. So as I said, I believe they're very reliable.
Doctor, do you yourself believe that drive tests are controversial?
While I do acknowledge that other people may consider drive tests controversial, I personally do not believe that they are controversial.
All right. I'll ask you a question. How did the drive test analysis affect your findings in this case today?
I found that the drive test just proved the basic science behind cellular tracking technology, which is that the margin of error at the boundaries makes it impossible to know exactly where Gardner's cellular phone was at the crucial moments when the Walters was being robbed.
And how did you conclude this, doctor?
During my drive test, I parked in the alleyway at approximately 1:20 a.m. and turned the replica phone on. I then stood in that alleyway until 2 a.m. From my results, I found that my first two connections were with Tower 109X, just like Gardner's cellular phone had when he was working at the Engineers Club. My last connection was with Tower 16X. This proved to me that a cellular phone can and will connect to Tower 16X from the alleyway, even if antenna X is not necessarily oriented to include the alleyway in its default range.
Now, doctor, based on all of your analysis, what is your opinion on the location of Izzy Gardner on the evening of January 4th and the early morning of January 5th?
In my opinion, it's very possible that Gardner was in the alleyway during the crucial moments when the Walters was being robbed. Additionally, due to margin of error, it's just not accurate for Dr. Matthews to be claiming that the information today provides us with Gardner's exact location, since we're only given a range.
Thank you, Dr. Ibarra. No further questions at this time.
Cross, Your Honor.
Whenever you're ready.
Thank you. Good evening, Dr. Ibarra.
Good evening.
You're not here for free, are you?
No, as my compensation must cover my drive test and my time spent on this case.
Right, you make $600 an hour.
Correct?
$8,000 for in-court testimony.
Correct.
I want to move on and talk about some things that you put in your report. You say that Mr. Gardner could have connected to Tower 16 from the alleyway, right?
That is correct. After conducting my drive test analysis and reviewing the forensic evidence, I found that it is probable that Gardner could have connected to Tower 16X from the alleyway.
So that means that you think the alleyway and the Engineers Club are in range of Tower 16 in general, Y or X, right?
Correct, as there is margin of error at the boundaries, and that could have been present at the moment in question.
Just to be clear, not the margin of error. 16Y covers the Engineers Club and the alleyway, right?
Correct.
So if someone were in the Engineers Club and the alleyway for an extended period of time, they would probably connect to Tower 16 at least once, since it's in range of it, right?
Correct. 16X has margin of error at the boundaries, as I've repeatedly said. So Gardner could have connected to Tower 16X from the alleyway.
Permission to recall the overlaid demonstrative, the corrected version, Your Honor.
That's fine. And defense counsel, if you have any objections at any point, feel free to raise them.
Let the record reflect I'm displaying an overlay of what's been pre-admitted as Exhibit 12C and Exhibit 11E. You've seen both these documents before, right, Dr. Ibarra?
Correct.
So you just said that if someone were inside the Engineers Club and the alleyway for an extended period of time, they should connect to Tower 16 once or twice. That's what you just told me, right?
Correct. After reviewing forensic evidence and conducting my drive test, where I did stand in the alleyway and I did connect to Tower 16X. Correct.
Thank you, Dr. Ibarra. So Miss Gardner was in that area for 8 hours, right?
Correct.
So when Miss Gardner got there, she must have connected to Tower 16. You just said that she would.
Correct. As not the Engineers Club, I'm talking specifically about the alleyway next to the Engineers Club.
You know, Miss Gardner was in the alleyway. Mr. Gardner was in the alleyway at least once that night, right?
Correct, as he was looking for his wallet.
So if that area is in range of Tower 16, maybe sometime within the next few hours, Mr. Gardner connected to that tower?
I'm not exactly sure what you were saying. Could you explain?
You say that that area is in range of Tower 16, so Mr. Gardner must have connected sometime before the end of his shift, right?
Correct, as well. Gardner was in the engineers club, and I'm talking specifically about the alleyway. And I'm testifying here today to say that Gardner could have connected from the alleyway to Tower 16X.
I know that, Dr. Ibarra, but to be clear, you know Mr. Gardner went into the alleyway at least once, right?
Correct, as he was looking for his wallet, so he was in
earlier in the day while Mr. Gardner was at work, he went into the alleyway at least once with a yes or a no.
Correct.
And earlier you told me if someone were in the engineers club and the alleyway for an extended period of time, they would connect to Tower 16 at least once or twice, right?
Correct, but as Gardner was in the alleyway, that could have been for a moment, just a couple seconds. But Gardner, from his alleged whereabouts, claims that he was in the alleyway for an extended period of time, which showed up in the drive test and the probable margin of error at the boundaries.
Dr. Ibarra, I want to make sure I'm being perfectly clear. While Mr. Gardner was at work for an extended period of time, like these records I'm showing you right now, he never connected to Tower 16, even though you said that area is in range of it.
I was talking specifically about the alleyways, as I've repeatedly said. And
Dr. Ibarra, earlier I drew a circle around an area.
Your Honor, badgering my witness, I would ask that the prosecution attorney allow my witness to respond at least a couple of sentences before the prosecution attorney moves on to her next sentence, if that's all right.
Overruled.
Dr. Ibarra, earlier I drew a circle around the engineers club in the alleyway, and you said that if someone was in that area, they should connect to Tower 16 once or twice. Mr. Gardner never did that, did he? With a yes or a no?
No, Gardner did not connect, but again, margin of error is present at the boundaries.
The only time Mr. Gardner ever connected to Tower 16 just happened to be while a theft occurred next door. Is that what you're telling me, Dr. Ibarra?
Correct. After analyzing the forensic evidence, I did conclude that Gardner's alleged whereabouts is completely consistent with the forensic evidence, which, again, as given with margin of error at the boundaries, that is very probable.
Okay, Dr. Ibarra. No further questions at this time, Your Honor.
Any redirect?
Yes, Your Honor, a brief redirect. Dr. Ibarra, can you please restate your main conclusions from your analysis of this case?
Of course, I concluded that Gardner's alleged whereabouts is completely consistent with the forensic evidence that I analyzed for this case, and the potentially incriminating timestamps from 1:38 to 1:50 a.m. can be explained by margin of error at the boundaries. And lastly, my drive test proved that it is very possible that Gardner's cellular phone connected from the alleyway to Tower 16X, just like Gardner had stated.
Thank you, Doctor. No further questions.
I assume there's nothing further from either side. So Dr. Ibarra, you're excused. Thank you for your testimony. Defense, do you have any further witnesses?
No, Your Honor, the defense rests this case.
All right. I'm showing 7:08 on my phone. It's about to be 7:09. So let's just, to make it nice and easy, let's call it 7:15. Let's return at 7:15 for closing arguments.
Yes, Your Honor.
All right, are the parties ready to proceed?
The defense is ready, Your Honor.
I believe defense goes first, but the state is ready to proceed as well.
All right, sounds good. Defense, whenever you're ready, go ahead.
Yes, Your Honor. May it please the court, 36 minutes. That's how long it took Izzy Gardner to find his wallet on the morning of January 5th, 2020. Frantically searching in the cold, he could have given up, but he didn't, because he's too familiar with the taste of being poor. Members of the jury, Izzy Gardner started working at 14 years old to support him and his mother. And after graduating high school, Izzy Gardner traded his time and youth to working jobs so that he could survive. Finding that wallet meant everything to him. Simultaneously, a robbery occurred at the Walters Art Museum on the morning of January 5th, which is why we're here today. The prosecution is charging the defendant, Izzy Gardner, for theft, first-degree assault, and second-degree assault. In order to convict the defendant, the prosecution must prove their case beyond a reasonable doubt. But the prosecution didn't fulfill the elements of their charges today because they first must prove that Izzy Gardner was at the museum during the robbery, and he was not. Allow me to break down the evidence. We first heard from Jamie Banerjee, a Walters security guard who worked at the museum on the morning of the robbery, testify that one of the robbers sounded like an Izzy Gardner. But when asked upon, Ms. Banerjee said that she wasn't sure if it was the defendant because she wasn't thinking clearly. Ms. Banerjee also admitted that the voice didn't really sound like Izzy Gardner. It sounded like an Izzy Gardner attempting to disguise his voice. But Ms. Banerjee has never heard Izzy Gardner disguise his voice. And Ms. Banerjee didn't see the robber's face. We heard from the prosecution's expert witness, Dr. Matthews, that Izzy Gardner's phone connected to Tower 16X at 1:38 a.m., locating his phone in a range that includes the Walters Art Museum, but not the alleyway between the museum and the Engineers Club, which is where Izzy Gardner found his wallet at 1:46 a.m. Because of this, the prosecution is claiming that the defendant did in fact enter the museum that morning. But Dr. Matthews admitted that he cannot pinpoint Izzy Gardner's exact location, because while the range includes a portion of the Walters Art Museum, it also includes a portion of the alleyway. And while Dr. Matthews said today that the alleyway is not included in 16X, we saw today that it is clearly included in 16X, as Dr. Matthews created the maps himself. Furthermore, Dr. Matthews also admitted that there's always room for margin of error and data points found through cellular tracking technology, which is what I would like to talk about next. To check the accuracy of Dr. Matthews' test, Dr. Ibarra recreated Izzy Gardner's actions through a drive test, and she found different results than Dr. Matthews did. Dr. Ibarra stood in the alleyway between the Engineers Club and the Walters Art Museum from 1:20 to 2 a.m. And despite not entering the museum at any point in time, her phone also connected to Tower 16X, proving that Izzy Gardner's phone could have in fact connected from the alleyway instead of the Walters Art Museum. In Warfield v. State, it states that presence alone at a place where a crime has been committed is not sufficient to establish participation in the crime. Not only was Izzy Gardner unaware of the crime, he wasn't even present at the scene. Since the defendant wasn't present at the scene, he couldn't have stolen the artworks. He couldn't have been able to use a firearm. He couldn't have been able to intentionally frighten others with the threat of physical contact. He couldn't have been able to attempt or cause immediate harm to others. Thus, all elements of theft, first-degree assault, and second-degree assault cannot be fulfilled. But the question remains, who did it? Who robbed the Walters Art Museum on the morning of January 5th? Now let's trace back to what happened after the robbery occurred. When Detective Barnes talked about her forensic investigation today, she said that she found Sidney Ross's fingerprints on the lower left exterior of one of the stolen paintings, Springtime, but she didn't find the defendant's fingerprints anywhere in the museum. Ironically, Sidney Ross quit her job at the Walters Art Museum just 2 days after the heist. When Detective Barnes called Sidney Ross, her phone was out of service. And when Detective Barnes stopped by Ms. Ross's house, no one was home. Even after all that, Detective Barnes still didn't further investigate Sidney Ross. Instead, she closed the case without finding a second suspect and continued to pin the blame on Izzy Gardner. But as we heard today, the detective didn't even take the defendant's story into account. Detective Barnes never asked Izzy Gardner where he was on the morning of January 5th. Instead, Detective Barnes directly accused Izzy Gardner, went to search his apartment, and ultimately didn't find anything. Members of the jury, Detective Barnes admitted today that without Casey Hudson's eyewitness account, it would have been difficult to focus her investigation on Izzy Gardner. But Casey Hudson was blindfolded during the robbery. Detective Barnes admitted today that she once told the FBI she wasn't sure if she had the right person. Detective Barnes admitted today that she didn't check all possible angles. The prosecution simply failed to investigate their case. And the prosecution has the burden to prove their case beyond a reasonable doubt. Members of the jury, I remind you that reasonable doubt is when the proof is close to an absolute certainty, when there's no reasonable situation that could have occurred other than what the prosecution presents. But the evidence presented by the prosecution today are all circumstantial. Just because Izzy Gardner was nearby the Walters Art Museum doesn't prove that he was at the Walters Art Museum. Just because Izzy Gardner deposits $7,800 doesn't prove that he stole the art. The prosecution argued today that Izzy Gardner was desperate simply for paying his January rent money 4 days late, in which we heard that his roommate Armani Lee didn't have a problem with. The prosecution argued today that Izzy Gardner was deceitful, but he didn't lie. He's a 19-year-old boy. And as to the $7,800 that the prosecution questioned the defendant about, we clearly heard today that it was a Christmas gift from the defendant's uncle. Members of the jury, Izzy Gardner was near the Walters Art Museum looking for his wallet on the morning of January 5th, 2020. He wasn't at the museum. He didn't do it. He didn't even know about it. He was simply nearby the wrong place at the wrong time, and nearby presence does not equate to crime. So we ask that you find the defendant, Izzy Gardner, not guilty for theft, first-degree assault, and second-degree assault. Thank you.
Thank you, counsel. State, whenever you're ready, I'll hear from you.
Yes, Your Honor. May it please the court, counsel, and members of the jury. Ms. Lee just told you on her closing argument, nearby presence does not equate to a crime. Now, if the only thing Mr. Gardner did that night was be near the Walters Art Museum, Ms. Lee would be absolutely right. But Mr. Gardner wasn't just near the museum that night. Mr. Gardner was desperate for money right before the heist. His financial problems were miraculously solved just the day after. He was identified in the museum, and his cell records placed him in the museum as well. This is a case about desperation, deceit, and $7,800. We've charged Mr. Gardner with 2 crimes, theft and first-degree assault. Now, we hold the burden of proof in today's case, which means we must prove each element of each charge beyond a reasonable doubt. We're confident that we've met our burden today, so let's start by looking at theft. In order to convict Mr. Gardner of theft, we must prove 3 things. That Mr. Gardner stole this art, that he meant to steal this art, and that the value of this art was more than $100,000. Nobody disputes the 3rd. To show you why Mr. Gardner did steal this art and why he did mean to steal this art, let's talk about how he was desperate. Let's talk about how he was deceitful. And let's talk about his $7,800. First, we know Mr. Gardner was desperate. He told you himself that just before the Walters was robbed, it was a really hard time. He was fired from the Walters in November, losing his only source of income, and a $500 fine just put him deeper in debt. His new job at the Engineers Club didn't even pay him enough to make rent on time in January. He was desperate for money. Let's talk about how he was deceitful. Now, the defense just tried to tell you that Mr. Gardner was in the alleyway between the Walters and the Engineers Club looking for his wallet during the time of the theft, and that his incriminating cell records could be explained by margin of error. But Dr. Kenya Ibarra herself, on cross-examination, told you today that if someone was in the general area of the Engineers Club in the alleyway on the night, then they should connect to Tower 16. But members of the jury, every single time Mr. Gardner connected to a tower while he was at work, he connected to Tower 109. Tower 109 was stronger. The only time Mr. Gardner connected to Tower 16 at all, when he claimed to return to the same place just an hour later, was in the exact time frame while a theft occurred next door. Mr. Gardner lied about where he was that night. That's not the only time he was deceitful. Because you heard today that Mr. Gardner deposited $7,800 into his bank account just the day after the theft. And you heard that he was short on money right before the heist. And you heard that when Detective Barnes asked him about where that money came from, the first thing he said was, "You know about that?" You heard that he waited so long to say something next that Detective Barnes had to make sure he was still on the phone. Is that something you would do if you already knew what you were going to say? Then Mr. Gardner offered his explanation that this money came from some Uncle Andy. Members of the jury, that's an uncle with no phone number, no email, no address. Mr. Gardner doesn't have the note he said this present came with. He doesn't have the envelope. He never told his roommate who he owed rent that he supposedly had $8,000 sitting in his apartment. It's been more than a year, and there is no trace of Uncle Andy. Uncle Andy doesn't exist. Let me be clear. We're not saying that this money came as a direct proceed from the art heist. We're not even necessarily saying that Mr. Gardner sold it on his own. We know at least one other person was involved in the theft. But what we do know is it didn't come from some Uncle Andy. And that means Mr. Gardner lied. Why would he lie if he had nothing to hide? Let's talk about assault. In order to convict Ms. Gardner of first-degree assault, we must prove all 4 elements of second-degree assault and that the assault was committed with a firearm. Second-degree assault, intent to frighten, we must prove that Mr. Gardner meant to place Ms. Banerjee in fear of physical harm, that Mr. Gardner seemed like he could hurt Ms. Banerjee, that Ms. Banerjee was scared she would be hurt, and that it was not legally justified. And we must prove it was committed with a firearm. That night, Ms. Banerjee was tied up, blindfolded, and thrown to the ground. When she tried to struggle, Mr. Gardner gestured to a gun on his hip and said, "Don't make me use this." Ms. Banerjee identified that thief as Mr. Gardner. Mr. Gardner meant to gesture to his hip. Mr. Gardner meant to say those words. That's a crime. There's no legal justification for those actions. The defense just told you that all we have is circumstantial evidence. So I want to be clear, members of the jury, you're about to get some jury instructions that will explain to you that circumstantial and direct evidence have the exact same legal weight. They want you to believe it's a coincidence that Mr. Gardner was short on money the day before the heist and had $7,800 in cash the day after. They want you to believe it's a coincidence his cell records mean he lied about where he was. They want you to believe it's a coincidence that Mr. Gardner was identified by someone who calls him a friend. They want you to believe it's a coincidence there is no trace of Uncle Andy to this day. Mr. Gardner isn't having bad luck, and those aren't coincidences. This is a crime. Find him guilty on all counts. Thank you.
Thank you, counsel. Everyone could give the judges just a moment to finish and submit our ballots. And the judges, as soon as I've submitted mine, I will start checking with you all. If you could maybe just drop a notification in the chat when you've submitted your ballot. All right, I'm seeing on my end that we just have one more person who's waiting to who's working through their ballot right now. So if everybody just hang tight for 1 second, what we're going to do in a second is as soon as those ballots are all submitted, I'm going to go off screen so that I can coordinate a few things behind the scenes, and I'll turn things over to the scoring judges to give their feedback. Just bear with us just one moment and we'll get going with that. All right, all judges' ballots have been submitted. I've confirmed that on my end. So I'm going to invite now all our panel of 5 scoring judges to go ahead and turn your cameras on. And competitors, obviously, it's up to you as to whether or not you'd like to turn your cameras on. I am going to turn my camera and my microphone off so that I can go work behind the scenes, and then I will pop back on in a few minutes to announce the results. I see Mr. Hellman up in the top left corner. So if you'd like to go first with your feedback and then sort of kick it to someone else once you're done.
Okay, thank you very much. It's really been an honor for me to sit in as mock trial judge for a number of rounds, including this final round. I haven't done it in a few years, and I did actually coach a team probably about 7 or 8 years ago. And I can tell why these 2 teams have made it to the finals. You're certainly both deserve to be here. It was really a job well done. And you all should be proud of yourselves. You really did a terrific job. And I don't know who's going to win, but whichever team wins deserves to win because you both did a fantastic job. Just a little my background. I have about 50 years of experience. I was a litigator for my career almost the whole time in Towson. And it's really great to see some people who I think will do very well as litigators if they do their homework tonight and continue on with college and law school. And I hope to see you in courtroom one day. Why don't I throw it over to who's the next judge in order? Oh, my old friend Dick Goodwin. I haven't seen you in a while down in Annapolis. So let me turn it over to Dick.
Yeah, I used to be in Annapolis. I'm now out in Fresno, California. No, I thought all of you did an excellent job. I think you're great orators. You clearly demonstrated the ability to think on your feet, which I think is a lot of it. I enjoyed the interplay of the objections and the arguments and watching you struggle, as all of us who've done litigation have done. But I think you're all going to do well. This is an excellent learning experience. I was admitted in 1975. I became a U.S. administrative law judge in 1996, and I've been on the bench since 1996. I'm also a retired Army Colonel in the JAG Corps. So when I was in private practice, my specialty, as Stan would know, is whatever walked in the door. But good luck to all of you, and glad I could be a part of it. So Barry, you show up next. So.
Okay, well, thank you very much. And I want to echo everything that you just heard about how prepared and how wonderful the presentations were and what an honor it was to sit and observe this. I do have a confession. My scores will not count because in part of my background, I have a son who's a recent graduate of one of the 2 schools. But I assure you that nobody else on the line knew that, and there is no prejudice. But knowing that one of the 2 schools, and I had an idea of which one, although I'm not sure, was my son was close enough to know the competitors, even though I don't know if he does or not. I informed Ben and MYLAW, and they said, "Don't worry about it. Have fun and score it." But I had the great benefit of being able to give everybody all 5s, which is what I think was deserving. I did, one of the things I loved about what I saw tonight was how both sides had their themes, and the prosecution, your theme, which you brought out at the very beginning, was strong. with the desperation, the deceit, and the money. The defense side, I think, was much more of a sympathetic theme, but I loved how the defense, in closing, took the prosecution's theme and tried to make it their own. I thought that was wonderful, and I loved how then the prosecution, in their closing, made sure not to leave that in the defense's hands and take it back. And that's, trying to make what the other people say work for you is a huge part of what we do. And that's part of listening and being smart and thinking on your feet. And I think everybody did that all beautifully. I guess who's next? Is that Alan? Have you gone?
No, thank you. I agree with everything everyone said so far. I've been judging these since the beginning of this competition, not since the beginning of time, but since the beginning of this competition. And I mentioned this to at least one of the other teams has heard what I'm about to say. You all have poise, you all have the presence that a lot of people don't have. You all have the presence, and that's why you're all here now, and that's something in you. And maybe that's what even makes you think this is something you may want to do at some point in your life. What the two teams here demonstrate that other teams didn't demonstrate is the ability to learn as you're going along. And this is something that we do lifetime, is you learn what works, you learn what doesn't work, you learn when to take chances, you learn when it's not worth it, and you make better decision making. And trials are, for however long a trial lasts, every single second you're making one decision or another. And it's just constantly listening to what's going on and making decisions. And I've seen that. And I've seen that with, I know I had at least one of the teams because I judged on Tuesday. And I think the other team I had early on in the competition. And that growth, that ability to become better at what you're doing 3 weeks after you did it the first time is just, for me, has been a joy to watch. And I can't, you could apply that to those of you who become trial lawyers. You can apply that to those of you who become anything else. But you've got it as far as the presence go, and you've got the intelligence and willingness to learn. And that's going to make you successful. Good job, both teams. Fantastic. And Natasha, you're last.
Hello. I was so pleased when you all showed up on screen and I saw who the teams were. I think this year, which is, I think I shared with you all, was my first year in participating in this competition, because really for the past 15 years, I've either been coaching one of my children's teams in lacrosse or basketball or soccer, or taking them somewhere. And so this gave me the opportunity to really participate, and I jumped in, and I think I probably participated in maybe 8 of these. And so the growth that Mr. Orlando was referring to, I had both of you all last week, and I just loved, I was beaming with the changes that both teams made in improving your presentation and improving the information that you were eliciting from the witnesses on direct examination as well as cross. You guys, I mean, there's a reason why, you're the best of the best and you're here. And I am a true staunch competitor. So, I would not like to be second, but the fact of the matter is you can't just go away and say, well, I didn't win it, and that's it. You have to be proud about what you've done, the time you've put in, and especially under the stresses and in this environment of our Zoom world of the pandemic and everything. You have to take away pride in yourselves. And then also you guys agreed to compete against each other, right? Because you guys could have just said, all right, we're co-champs. Excellent, we're great. We got the Zoom, we got the Google Meets, but you all gave us this additional nugget. And so I thank you all for doing this this week, and congratulations to the both of you.
All right, thank you to our judges. We recruited for our judging panel tonight folks who've been judging, some for many years in this competition, but folks who've judged throughout the season. And we did that specifically because we wanted to give you all a judging panel that understood this case and understood this activity so that they could judge as fairly as possible. A couple of the judges have mentioned this already, but of course, no matter what the results are tonight, the two teams that are on here are co-champions. As you all are aware, this season we divided into, we had the Microsoft Teams division in the regular season, but really two divisions, the Zoom division and the Google Meet division. And those divisions finished up on Tuesday. Our prosecution team this evening was the Park School of Baltimore. The Park School was the champion of the Zoom division and was named co-champion. Our defense team this evening was River Hill High School. River Hill was the champion of the Google Meet division and is our second co-champion, and gamely agreed on very short notice to jump onto the other platform and to use Zoom tonight so that this round would be possible. We're very grateful to the entire team and coaching staff at River Hill for making that happen on short notice. So no matter the results this evening, you all as the Park School of Baltimore and River Hill High School will always be listed as co-champions. Tonight's matches just to determine who will be listed as champion amongst those two teams. This was an excellent trial. To go back to what Barry was saying a moment ago, he did recognize that conflict at the beginning of the round. As a result, his ballot did not count and mine did. That's why I did a ballot even as a presider, just in case. And so without further ado, the winner of this round and the champion of the 2021 Maryland high school mock trial season is the Park School of Baltimore. Congratulations to both teams on an absolutely fantastic season. The results will be available on Process momentarily. You should all be extremely proud. And I would be remiss if I didn't say that I would love to see any of you come to UMBC and work with my team in the future. You all are fantastic. And best of luck the rest of the way as you finish up this school year. And for those of you who aren't graduating, we look forward to seeing you next year. For those of you who are, we look forward to see you move on to continue to excel at the college level. Thank you all for participating and have a great evening.
Wait, before you log off, please, I am chair of the MYLAW organization, and Ben has been so outstanding. And I wanted to say this while everybody could hear and listen. Ben Garmo we couldn't have done this without him, and you couldn't have had this activity without him. And so I just wanted to give a huge shout out. Thank you from the board. Thank you from all the competitors. Thank you from all the judges. And just keep going. Keep going and keep doing it.
That's the last thing I'll say, and we should call it a night, is I started doing this activity when I was a freshman in high school. And I did it for 4 years in high school, several years in college, several years in law school, and I still coach it. It's the best thing I've ever done. And you all should be extremely proud of yourselves. And it was an honor to be able to preside over this round tonight. You all made it as fun as it possibly could have been. So best of luck to everyone moving forward, and congratulations.
Thank you, everybody.
Thank you so much.
Thank you so much.
Congratulations, both teams. Great.
Thank you.
Okay.